Good morning. This is the Board of Appeals, Town of Hempstead, February 5th, 2025, 9:30 meeting. Will everybody please stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands. Mr. Chairman, do you have any opening remarks?
I do. Excuse me, but I'm recovering. For those of you who have never appeared before us, the manner in which we conduct the hearings are as follows. We first call cases if there are any adjournments on the calendar. We will call those cases first. We're going to be able to hear anybody? Gentlemen, ladies, if you have a discussion that you'd like to engage in, please do it outside. So we would call the adjournments first, and then we get into the calendar. The procedure we follow with respect to the cases being presented is that the applicant will be given the opportunity to state their case. If there are any objections, they will be given the opportunity to be heard, and then we allow the applicant or the applicant's representative to sum up. If there are any objectors on any of the cases, we ask that you try to keep it as brief as possible, but we will hear whatever you have to say. If there are any number of objectors and they would simply like to get up and say that I agree with the person who spoke before me, that's fine. We accept all types of evidence. We accept emails, letters. We have plenty of those. And the proceedings are taken down, they're archived, they're videoed, so you can refer to them at a later date. And we do have a court reporter, so all the proceedings, we make a record. And once we close the hearing, we will not accept any additional evidence. We're not constrained by the strict rules of evidence. This is not a judicial body. It's a quasi-judicial body. All right? If there's anything I missed, I apologize. However, let's call the calendar.
Okay. Mr. Chairman, we have two adjournments for this morning. First case 7025 Levittown, Wayne and Carol Wichern, renewal of grant to maintain fence varying in height from 5'3" to 6'5". Also known as 124 Haven Lane.
Is there anyone here on this case? No? Okay.
Mr. Chairman, I did speak with the applicant, and he is away for this hearing. He is available for the February 26th hearing at 11 a.m.
Anyone else here on this case? Since there's no one in opposition, we're going to grant an adjournment to February 26th at 11 a.m. We have one more case for adjournment. It's case 7625 Alex A. Manhas and Serena Jail. Variance lot area occupied, front yard average setback, construct one-story addition, second-story addition, roofed over open porch, and install 2 AC units, all attached to dwelling, also known as 642 Lenore Lane. Anyone here on this case? Okay, mailing is defective, as a result of which we'll adjourn the case on our own motion. When is the next available date?
We spoke with the applicant March 19th at 11 a.m.
Any questions from the board? If not, we'll grant that. Okay.
Okay, we'll be starting with case 6825 Oceanside, Edward Kalmus, renewal of grant to maintain a 6-foot-high stockade fence, also known as 3329 3rd Street.
I would assume that to be the case. Anyone here on this case? Someone from outside?
case you hear?
Yeah, yeah. This case?
No, he's
No?
on
Okay,
77.
we're going to put that on second call. Next case.
Next, we have case 6925, Belmore, Andrew Smart, renewal of grant to maintain pool with surrounding wood deck and 6-foot-high fence with less than required front yard setback on Martin Avenue and larger than pool installation area, also known as 2053 Russell Street.
There is a Simmons on.
Yeah, yeah, he's here.
Andrew Smart, 2053 Russell Street, Belmore.
Good morning, Mr. Smart. So you're here for renewal of a grant to maintain a pool with a surrounding wood deck and 6-foot-high fence with less than required front yard setback on Martin Avenue and larger than pool installation area. Is that correct?
Yes, sir.
The building department inspected the premises, this is a renewal, on November 6th, 2024, and found that all conditions previously imposed by this board have been complied with. Do you have anything else you'd like to add, sir?
No.
Okay. Do I have any questions from the board? If not, do I have a motion?
Move, Mr. Chairman, that the hearing be closed, that the matter be placed on the decision calendar. Mr. Smart, you'll be notified by mail of the board's decision once it's rendered.
Second? Second. All in favor?
Aye.
Any opposed?
Have a
Any
nice day. You're
abstentions?
done.
That's it. You too.
Next, we have case 7125, Levittown, Orlando, and Ida Valencia. Renewal of grant to maintain 6-foot-high fence forward a dwelling which may substantially obstruct line of sight, also known as 35 Norman Lane. Swear affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Please take a seat, state your name and address for the record.
Jasmine Venegas, 35 Norman Lane, Levittown.
And what is your role in connection with
I
this?
live at the property. I'm the daughter of the owners of the property.
You're the daughter of the owner. Okay. All right, this too is a renewal of a grant to maintain a 6-foot-high fence forward of the dwelling which may substantially obstruct the line of sight. The building department inspected the premises on November 12, 2024, and found that all conditions previously imposed by this board were being complied with. Do you have anything else you'd like to add?
No, I do.
Okay. Do I have any questions from the board? If not, do I have a motion?
Mr. Chairman, move that the hearing be closed, the matter be placed on the decision calendar. I hope I pronounced this correctly. Ms.
Venegas.
Venegas, you'll be notified by mail of the board's decision once it's ready.
Second. All in favor?
Aye. Have a nice
Thank you.
day.
Have a great day.
Next, we have case 7225, Merrick, Arthur Tassilello. Renewal of grant to maintain 6-foot-high PVC fence in principal front yard and clear sight triangle at applicant's driveway, and 4-foot-high picket fence within the clear sight triangle on State Street and Frederick Avenue, also known as 1899 State Street. Mr. Chairman, there is an application for an appearance waiver on
All
this
right, we
application.
will grant the appearance waiver. For the record, the building department inspected the premises on November 14, 2024, and found that all conditions previously imposed by the board were continually being complied with. Do I have any questions from the board? If not, do I have a motion?
Move that the hearing be closed, the matter be placed on the decision calendar. The applicant will be notified by mail of the board's decision once it's rendered.
Second?
Second.
All in favor?
Aye.
Any opposed? Any abstentions?
Next, we have case 7325, Merrick, Ionis Babaksikos. Renewal of grant to maintain 2-family dwelling with detached 2-car garage in Res B District, also known as 1880 Meadowbrook Road.
Patrick, that was
Come on.
performance on the pronunciation.
Yanis Babatsikos, 1880 Meadowbrook Road, Merrick, New York.
Good morning. You're here on a renewal of a grant. For the record, I think Patrick explained what it was for. The building department inspected the premises on November 15th, 2024, and found that all conditions previously imposed by the board were being complied with. Do you have anything else you'd like to add, sir?
No,
I didn't think so. Do I have any questions from the board? If not, do I have a motion?
I would just move, Mr. Chairman, that the hearing be closed, the matter be placed on decision calendar. Sir, you'll be notified by mail of the board's decision once it's rendered.
Second, all in favor?
Aye.
Any opposed, any abstentions?
You too, thank you.
Next, we have case 7425, Merrick Barry Wallfish. Variances, lot area, front width from and on street line to front setback line, lot area occupied, side yards, aggregate, maintained dwelling with shed addition attached thereto, also known as 33 Dorothy Court.
Lisa Koshia with Permits R Us, 338 Jericho Turnpike, number 396, Syosset, New York, 11791.
Joe.
Good morning, Mr. Chairman and members of the board. Thanks. I'm here representing Mr. Wallfish, who wishes to maintain a dwelling with a shed addition. This property is located in a Residence B zone. Yes, you're welcome. The dwelling has a lot width of 43.06 feet, where 55 feet is required, and has a front yard setback of 20 feet, where 25 feet is required. It has a side yard of 3 feet, where 5 feet is required, and an aggregate side yard of 11 feet, where 15 feet is required. The lot coverage on this property is 28.5%, where 27.5% is required, which is just a 1% overage. The dwelling was constructed around 1931 and has existed for 94 years without incident. Mr. Wallfish respectfully requests your approval. Yes.
Are they all going to be closed out?
Yes, they will.
Any other questions?
So they never obtained a CO for the house 70 years ago.
No. There was no CO.
And this is not within what they used to refer to as the campgrounds.
I
Okay.
don't know. I'm not sure.
Becky, so they filed for a non-conforming but didn't, I'm sorry, hold on. Ms. Kachia?
Yes.
They filed for a non-conforming or no? I know it didn't satisfy it, I think. They did file, but it was denied? So what was, since we have front width from and on the street line, usually that comes with being asked to determine that a lot is acceptable as a building lot, right? It usually comes up in a subdivision, obviously. So I
See that.
consulted with Ms.
Thank you.
First, and she indicated that she thought that it was two lots owned by the same people. They had a legal house on one, without a benefit of a permit, built a house on the other one, which isn't itself a legal building lot by way of its size. So now, similar to a subdivision, we're being asked to legalize this lot. Now, Ms. First had thought that it had applied for non-conforming, but determined not to be, am I correct?
The house applied for non-conforming and determined that the house was built in 1931 on that lot.
All right, on the cusp. Do we know if, from what I understand, when they started this, like in 3031 with the building department,
1938, the tax assessor determined it was 50% depreciation on the building.
but I thought that in 30, 31, and maybe 32, they were going through getting it all done. So there might be some people who weren't yet subject to zoning in, let's say, 31 or. I know, but I thought that it took time for them to get through the whole town. So it could have innocently been that they built it, even though it was 31, you know. Okay.
Would that, could you not determine that from tax records going back? That it was built in 1931, not 30?
So it's a one-day thing, okay. Let me just see the size of this. I apologize, Ms. Kachia, if you already answered some questions, because I was
When was that,
educating myself.
when was that rear addition put on?
It looks like the rear addition, I think it was 1960, hold on. Yeah, permit was filed in 1960 for two 18-foot dormers, so it looks like that was done
This is more than a dormer.
in the 60s. Two 18-foot dormers?
The dormer's on the second story. This is the first story. And there's 3 doors to the house.
Well, was it a two-story addition, or maybe she means the second story was the addition?
This looks like a new foundation.
Yeah, it does to me, too. Well, it could have been in 1960, no? I don't know.
It could have been, but
So wait,
this is,
Ms. Kachia, if I missed it, I apologize.
That's okay.
How did your client come to know that these things had to be legalized?
So they went to sell the home last year. It was my client's parents' home, and when they went to sell it, they realized that the house never had a C of O, so they had to go through the process of legalizing.
Is there money in escrow?
Yes, there is.
the attached shed, what is that used for?
It's just storage. There's a door just on the outside. You can go in there and,
Is there a basement to the dwelling?
no, it's only a crawl space, no basement.
Okay, and I think you probably put these numbers on the record when I was counseling with Ms. First. But the lot area occupied is just 28.5 in total, 27 allowable, 27 and a
Correct,
half.
it's 1% over.
And side yard, am I correct, five required, you're asking for 3, aggregate 15, and you're asking for 11?
Correct.
Okay. So they're relatively de minimis in otherwise.
She's got open permit.
Miss First,
Said she's gonna,
The-
they'll all be closed out.
attached shed,
See, that's Joe.
since it's maintaining a 3-foot side yard, would that have to be fire rated? And that fire rating requires extensive work. It has to be protected on the inside and the outside, and
Ms. Kachia, have you been in the house?
Yes,
And in that rear portion with its separate entrance, or seemingly, is there only one kitchen in the whole house?
it's only one kitchen on the main floor.
Is there any kitchen on the second floor?
No,
Okay.
just
I
bedroom.
thought you meant that, but the way it was worded, I wanted to be
No,
clear.
it's on, there's only one kitchen and it's on the main floor. That's what I meant to say.
how hard is, in your opinion, you may or may not know, how hard is it to remove that attached shed? And I'll tell you before you answer, that's going to require extensive work as far as upgrading it to the fire rating.
Well, the siding encompasses the shed because it looks like it's actually a part of the house. It's built onto the side. So it's probably extensive to remove, but
It's
They'll have
vinyl
to-
siding.
yeah,
Is the garage a garage?
yes.
They're right next to a park.
A 3-foot side yard is not good. This is very easy to remove. It's gonna have to be fire rated regardless of where it is. This, in my opinion, should be denied so that they maintain this proper side yard. Sheet rock, inside and outside. I'm sure, you could ask her, I'm sure there isn't.
Is there any sheetrock in the inside of that shed?
Honestly, I don't remember if there's sheetrock in there. I don't remember if I saw sheetrock. I don't
Would your
know.
client be willing to do what's required? 5/8 inside, 5/8 outside?
I'm sure there's money in escrow to try to legalize everything. If, in order to have it legalized, they are gonna have to fire rate it, then they're gonna have to do it. Yeah.
So if the shed were not there, it would be a 5.5-foot side yard?
Yeah, yes. The shed is 2.5 in width and 3 feet on the other side, so 5.5 would be on that side.
Yeah, but it still needs it. And Why do they have 3 entrances? That's kind of weird. And the rear entrance looks like it's going to be a separate unit.
I don't know. It's not a separate unit. It is part of the home. I don't know why.
I have no further questions, Chairman.
Any other questions from the board? If not, do I have a motion?
Move that the hearing be closed, the matter be placed on the decision calendar. Ms. Kuchia, you'll be notified by mail of the board's decision once it's rendered.
Thank you.
Second,
Second.
all in favor?
Aye.
Thank you.
Next, we have case 7525, North Belmore, Donna Sarfati, mother-daughter residence, second kitchen, also known as 2185 Rosemont Street.
Yes, ma'am. Please state your name and address for the record. Chris Gray, Architect, 2401 Capri Place, North Belmore, New York, representing Donna Sarfati, located at 2185 Rosemont Street, North Belmore, New York. Good morning. My client wishes to apply for a mother-daughter residence. This is a existing one-story home, and application was filed and approved for a new second floor. That was under application 24-7376. And seated to my right is, starting from the left, is the owner, Donna Sarfati, her daughter, Jacqueline Sarfati Macaulay, and the owner's son-in-law, Patrick Macaulay. The owner, Donna, would like to remain on the first floor, and the new second floor to be constructed would be occupied by her daughter, Jacqueline, and her son-in-law, Patrick. They are aware of the rules that this must maintain a one-family appearance with one doorbell, one gas electric meter, and one mailbox. That is our case.
As you know, Mr. Gray, the Board of Architectural Review reviews each application for a mother-daughter or immediate family use to determine whether or not the residence is suitable for such purpose and whether or not it's revertible to a single-family dwelling at the cessation of such use. In this case, and sometimes they make recommendations, as you know, and we give you an opportunity to just tell us why that may or may not, those recommendations may or may not be feasible for safety reasons, cost reasons, et cetera. In the case of this application, the Board of Architectural Review has determined that the dwelling is suitable for such use and is restorable to a single-family dwelling at the cessation of such use, with one provision that there's no illegal occupancy in the basement. I have to put that on the record, and I want your clients to know, I'm sure you've advised them, there shall be no illegal occupancy in the basement.
Yes.
You know also, yes, you have an open building permit for maintaining and fencing.
Yeah.
Is that
Those
fencing?
were applications filed initially at the time of the new construction.
Right.
And the mother-daughter were filed. It was discovered the fence did not have a permit, so that was applied for, and I believe
Wait.
it was already, the permit was issued.
Okay, so that, you're not gonna end up before us for that, right?
Not at all.
Fencing is not forward of the dwelling?
No, it's all in compliance.
Okay.
The, how many cars can you park off-street at the premises? And how many cars do your clients have?
Well, there are 3 occupants and 3 cars, and they can all fit on the property. The garage is still a garage, and then there are 2 spaces available in the driveway.
Okay. Any other questions from the board? If not, do I have a motion?
Mr. Chairman, I would just move that the hearing be closed, the matter be placed on the decision calendar. Mr. Gray, you and your clients, if they've signed in, will all receive a copy of the board decision once it's rendered. Thank you all.
Thank you very
Have a nice
much.
day. Good luck.
Second.
Next, we have case 7725, Levittown, Satwinder Bariana. Variance front yard setback on Roxbury Lane, construct a roofed-over porch and vestibule attached to dwelling, also known as 3229 Roxbury Lane.
Okay.
Peter Toth, 370 Harrison Avenue, Massapequa, New York, 11758.
Can you say your last name again?
Toth, T-O-T-H.
Okay. Make sure you speak in the microphone because it's harder to hear than you'd expect, and she needs to be able to hear you to take everything.
Understood.
Okay, Mr. Tolton?
We're requesting a front yard variance.
What is your relationship to the owners?
Expediter.
Expediter.
We're requesting a front yard setback relief for a construction of a roofed-over porch and vestibule attached to the dwelling, where 25 feet is required, and we have 20 to the vestibule that's connected and 17 to the steps.
What was to the step?
To the vestibule is 20 feet, to the steps is 17.
17.
I also have letters of no contest from all the neighbors, signed with telephone numbers and addresses. Thank you.
So I'm looking at the photograph you submitted, and there's an enclosed entryway. I would have probably
That
called
is the
that a
vestibule.
vestibule?
Yes. That's what's, when you reach that, it's 20 feet. The steps coming down is 17.
Hold on. I thought you wanted to construct something. Are you here for maintaining that?
It's under construction.
Okay, hold on.
That
What I'm-
vestibule itself was existing, and they're building on top of that vestibule.
Can you come up here for a second?
Sure.
Can you approach? Construct roof over porch and vestibule. So is this the vestibule?
That's the
So that's, you need to, you're,
closing this vestibule here and the constructive porch, so the porch is over here. They're doing interior work.
okay, hold on.
This,
Go,
this
let me
doesn't-
do this.
This doesn't tell
Is
you who
the
drew that.
structure, is the construction of this thing that has brick on it,
Why?
is that
Somebody has to be
before us?
responsible for
That
it.
was before you, yes.
Is it right now?
It's there right now, yes.
No, no.
I mean,
I mean, that's like,
What are you,
I didn't do
is
that.
that s- vestibule already
Is that
legal?
something from the building department doesn't do?
It's all part of this permit itself. So like with this wasn't legal
Wow,
itself.
okay.
So now that they're doing
And we
this.
have to
it's
get,
not
could you
a
get the
construct-
applicant's exhibit?
What is your, are you
Because he's
wanting
gonna
to
do it.
enclose this awning thing?
They're enclosing here and coming out and then finishing.
But this, that's already built, are you asking, does that have a permit?
That has a permit with the house.
Okay, so you're not asking for that construction?
Well, it's, I guess how they worded it, putting it on a vestibule, it's really a roof over.
Thank you.
That's fine, that's fine. I'm just asking you, since I have a vestibule for me, if it's that
this
vestibule, or
is-
an extension of it.
It's that
Nicholas could have done this. I'm
No,
not
no.
responsible for
That
this.
vestibule is permit or not?
It's part of the house that has a permit.
You
So
keep
it's-
telling me that
It's
that's
part of the
before
house
me.
though, it has the permit. I have a,
back and we'll, Stephanie, just let the record reflect that the representative for the applicant has clarified that the existing vestibule shown in the photographs, covered in stone, matching the rest of the house, is not before us. It was a subject, was included in the permit originally for the building of the house, and that the items before us are actually construct items. Mr. Pellegrini has raised the issue, I know you heard when you were up here, that the site plan, plot plans
Wasn't stamped inside.
submitted before the board have no indication as to who drew them, no certification, no signature of an architect. So that I think we should adjourn this and let them get signed copies into us.
So it would be a rehearing, or I'm going to,
Yeah, we'll just have to have you come back once you get proper.
if I have that by today? I mean, this is something that could be signed and done by today. It's
Hold
not
on.
like,
Yeah, I understand, hold on.
It's not a file with a, with who,
right, but it was accepted by the building department, and I was put on to schedule. I understand where you're coming from. I'm just trying to, now have to tell the homeowner we have to come
Well,
back in X amount of
you're
time.
not the homeowner, so.
No, I know, but I have to tell the homeowner that we have to come back in X
Yes,
amount of time.
yes, you do.
Wait, hold on. Where's Christina? Christina. Mr. Jacobs drew the.
Who drew this plot plan, do you know?
Kurt Jacobs, it's on the sign and seal.
No,
It
no,
was
no,
just,
not the plans, not the
the
package.
plot plan is what they cropped off of the site plan A1, which they would be using for that. So they did draw that and then uploaded it for it.
You work with Kurt Jacobs?
I work with them, yes, for court to
With whom?
design. Yes, I work with them for court to design. I can go and get that done. I mean, I didn't realize that it wasn't signed. I know what stamp you're talking about. There's a stamp that
Yeah.
goes onto
Okay.
it completely. I know. I didn't see it.
Okay.
I was just
Okay,
aware that we
so,
were signed.
Mr. Pellegrini raises an important issue. I think solely because we have the plans signed and certified by Mr. Jacobs, we are familiar with Mr. Jacobs, and the plot plan submitted, while it does not meet the requirements, it does appear to be the same as the one that is signed and certified. The issue is the 30-day rule. I think that if you can, we've heard you've done presenting your case. I think if you can get these signed and certified and on file, I think it's harmless error that it wasn't on for 30 days, and we can put the case on reserve.
Okay.
And address the issue.
reserve decision, gotcha.
And address the issue when we do our deliberations.
You want me to bring an original link then, right? I'll bring it into original
Yes,
link and
please.
upload, so you
Yeah.
have both?
And given that there's no one here in opposition, I think it's harmless error.
Okay.
But make sure it doesn't happen again.
Yes, I understand.
If it's not identical, then you're gonna come back in and restate what you said.
Understood.
Okay. Obviously, identical means what you're
Exact-
applying for
yes,
as
sir.
well.
Nothing, yes, no numbers changed or anything like that.
Yes.
What's uploaded is what's uploaded, and
Right.
that is correct, it's just missing the
I
stamps.
want to, don't fudge on identical if you're doing
No, I
something
understand.
different.
I'll never do that, it's not worth it.
I understand, I agree.
Okay, that being said, you're done with your case, right?
Understood.
All right, are there any other questions from the board? If not, do I have a motion?
I move the hearing be closed, the case placed on the decision calendar when the board,
Reconvenes.
actually, it's not closed, it's going to remain open until you submit that paperwork.
Right, and you guys will reconvene, and the final
Yes.
decision will be made
For the-
in X amount of weeks.
Yes, for the limited purpose of accepting a signed and sealed plot plan.
Understood.
Okay,
Thank you.
I guess we don't need a second. I don't know. Okay.
Thank you.
Next, we have case 7825, Baldwin, Jackie Covington. Variances, front yard setback on Centennial Avenue, rear yard, construct one-story addition attaching dwelling to detached garage, and convert portion of existing garage to living space, also known as 966 Centennial Avenue. Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Please take a seat, state your name and address for the record.
Good morning, members of the board, Mr. Chairman. My name is Ashley Lowe-Keene from Mark Anthony Architects. Our office is located at 1563 Belmore Avenue in Belmore, New York. I am here today on behalf of my client, Jackie Covington, who is the owner and occupant of the subject property located at 966 Centennial Avenue in Baldwin, New York. We are here today as a result of an application that was filed under tracking number 22-12590 for a proposed one-story addition and proposed garage conversion. The proposed front yard setback for the second front yard, as this is a corner property, is proposed at 22.72 feet, where 25 feet is required for a corner property in a Residence B zone. We are requesting relief of just 2.28 feet. The front yard setback currently exists at 23.2 feet, making the difference just 0.48 feet between what is existing and what is being proposed for the front yard setback. Additionally, the proposed rear yard setback is 7 feet, where 15 feet is required, for which we are requesting relief of 8 feet. The existing the existing detached frame garage currently has the same setback of 7.0 feet, for which we are requesting relief for the proposed garage conversion.
Wait, I'm sorry.
Rear.
Slow. What is your front yard number again?
So it's the second front yard, 22.72 is
22.72.
proposed.
Okay, I thought you said
Versus
something else.
25.
And then what were you telling me about, you only need two things, right? Rear yard and front yard?
Yep.
Yes.
Okay, so what was mentioned of the garage for? The last thing you said was
Converting a
something about
portion.
your garage.
Yes, the garage has a setback of 7 feet, where 15 feet is required, so we need 8 feet of relief.
On the rear yard.
Yeah, because it's a corner property, so they're all different.
Right, but to me, it looks like the rear yard on the garage is, your rear yard has been defined as, I get it. What I
Technically, the
would call
rear-
your
yeah.
side yard, you've chosen to be your rear yard, or someone has.
Yes.
Okay,
So where the 57.38 dimension is for the lot, that's our rear yard.
gotcha, I see it.
And then technically, our second front yard is on Centennial Avenue.
Right, I understand.
There's only going to be a partial conversion of the garage?
Yes, for a laundry room.
Have you been in the house?
Yes, back in 2022, I was in the house, yes.
And what's in the basement?
It's a proposed crawl space.
Is it crawl space? Because that one. Oh,
Yeah.
How about the existing dwelling? What's in the basement there?
Just, it's unfinished.
Unfinished? Because it has a basement entrance, obviously.
It does.
I
The rear.
believe she just had a washer dryer down there. Just give me 1 second, but there's no finishings at all. It just
That she's gonna move upstairs now into the garage so she can have an
Yes.
apartment down there.
half, yes. No. I walked right into that,
You said yes.
but half of the garage is gonna become the lunchroom now
It's
upstairs.
an admission against interest, Joe.
Is there still an above-ground pool there?
Lozenges.
No,
Thank you.
No, it's been taken away?
yes. There's no pool in any of our pictures, no. And she does have 2 open permits for a handicapped ramp, and we filed another application to maintain a fence, which has been approved, and those will be closed out after the work is done, all at the same time.
Where's the ramp?
It's not on the plan.
I don't believe she has the ramp up anymore, but she never closed the permit out after she had it.
Is it, I don't see it on this plot plan.
And it wasn't there when we were there, but she does have the open permit, so we will have to close it out.
Those first.
No. No. Could we see the search?
What do you want, the search sheet?
Yes, please.
Yeah, there's an application for a ramp. But the ramp's done on the plot plan. Is it on Google? Is it on Google Earth?
No, it's not. Ms. First, does a handicap accessible ramp require, it requires a building permit, obviously, but does it require the necessary setbacks, et cetera?
Search here.
It's exempt. Thank you. That makes sense. So the issue could be that it doesn't, the building permits do not show a swimming pool, but Google Earth shows a swimming pool.
Say that again?
Google Earth indicates that the picture shows that there is this above-ground swimming pool.
There's not a swimming pool there anymore.
Okay, then.
Anything else?
No.
Any other questions from the board? If not, do I have a motion? Go ahead.
I see there's a rear basement entrance or a side basement entrance.
Yes.
Is there another kitchen downstairs? Have you
No.
been there? So what's in the basement?
Just the washer dryer, and then it'll become a proposed crawl space.
Okay, so it's just a utility area.
Yes,
Thank-
it's just like cement down there.
Thank you.
There's no finishing. Thank you.
Thanks, Don.
Mr. Chairman, I just move that the hearing be closed, the matter be placed on the decision calendar. Ms. Lowe, you'll be notified by mail of the board's decision once it's rendered.
Second?
Second.
All in favor?
Aye.
Any opposed?
Next, we have case 7925, Woodmere, Mark and Sarah Schmerler. Variances, lot area occupied, front yard setback on Carroll Avenue, rear yard construct addition, which is lower than 2 feet above base flood elevation attached to dwelling, also known as 942 Carroll Avenue.
That's the second time in a couple of weeks that we had this in that area. When is that become important?
Tina Pangallo, 549 Hempstead Turnpike, West Hempstead, New York, 11552.
Mark Schmerler, 942 Carroll Avenue, Woodmere, New York, 11598.
Good morning, Chairman, members of the board. I'm representing Mark and Sarah Schmeller of 942 Carroll Avenue, Woodmere. The property is located on the northwest corner of Carroll Avenue and Donald Lane in Residence B. We're requesting a variance to construct a one-story addition that violates the lot area occupied, front setback on Carroll Avenue, rear yard, and is lower than the 2-foot above flood base elevation attached to the dwelling. A state variance has been approved for that, and I'd like to submit a copy of that state variance.
We'll accept that.
We'll accept it in evidence.
The maximum lot coverage allowed is 27.5%. The proposed lot coverage requested is going to be 35.5%. The existing lot coverage for the dwelling is 20.7. With the deck, it's 26%, but the deck will be removed during the construction, along with the fencing.
And what did you say the ultimate? number?
35.5. The front yard setback required on Carroll Avenue is 25 feet, and the front yard proposed will be 23 feet. The rear yard setback required is 25 feet. The rear yard proposed will be 5.83 feet. Because this is a corner piece of property, this is the only area where the addition can be constructed. And I would like to submit letters from the neighbor to the west that this affects, and also 8 other neighbors indicating they have no objections
We'll
to the
accept
board
those.
granting this variance.
Ms.
Accept
Pengello,
those and evidence.
Yes,
Wait, so you want the rear yard to go to 5.8, where 25 is required. What is it currently? Because it looks like currently it's not even close to 25.
currently it's 20 feet.
Currently it's 20?
That's what I'm showing on here.
Oh, is this a corner?
Yes, this is a corner.
I see, so that's what I was looking at as a side yard, like the last case.
Right, exactly. So this, and like I said, that's really the only place they could put the addition, being that it's on a corner. The Schmieler family is experiencing many, yes, I'm sorry.
Hold on. On the plot plan I'm looking at, the hatched area, if you will, which is actually lined, it says remove deck, right?
Correct.
Is that where the addition's proposed? Or is it over on the side we're calling the rear yard that is currently 20?
The deck is going to be removed, and then
Right.
the one-story addition is in the rear yard.
Over where it currently 20, it's just not hatched?
Correct.
then? It's just not hatched, is it that area?
Yes.
Okay.
Oh, okay, I see. He's got the deck hatched, but that's going to be removed. and then
Right,
the
but that's
one-story
not where the
addition.
new construction's going. The new construction's going on that section sticking out that takes it down to, you said 5.8, mine says 5.10.
5.8.
Oh,
So,
okay, which
yeah,
is 5
5
feet 10.
5 feet 10 inches. Okay. So the Schmieler family,
Excuse
yes.
me, after the decking is removed, are you going to replace that?
You can replace the decking after it's removed here. This, in the back here, though. It's just going to be on grade.
So none of that 35.5 relates to decking?
That's
Is that
correct.
correct? Okay.
The Schmieler family is experiencing many challenges right now. Sarah's mom's health is deteriorating severely, leaving her ill and physically challenged. They need to make these modifications to make a handicapped accessible bathroom, kitchen, and dining room that can accommodate both her and the family of 8 children. This addition will help them function as a family unit while ensuring that the mother can be a part of their daily lives. I do have letters from the doctors indicating her mom's condition,
We'll accept those and evidence.
and we're respectfully asking the board to grant this variance.
Ms. Pangallo, so looking at the Google Earth satellite view,
Yes,
in looking at where it seems this expansion is requested, there's currently like a swimming pool there.
yes, that's gone. I was there and
So
took
that is
pictures.
the area where we're talking about.
Yes, that is correct.
And who owns that hedge? Do you know? Is your client?
That's the neighbor's hedge.
So this is going to go, I'm not clear, that hedge may be in the way, right? Because you're proposing,
I mean, there's no,
A
there's
15
trees.
foot-
The neighbor has trees, the neighbor on the side has
yeah,
some
but,
trees.
so you're going to go out 15 more feet toward that side, right? And then there's something that says a concrete patio on grade. It just doesn't even look like there's room.
Well, maybe if you, I don't know what Google Earth is showing, but maybe they're not there anymore. Let me get my phone and
Yeah,
look at
come on.
Google Earth to see what trees you're
No,
talking
you
about.
can look here,
Yeah,
Ms.
that's showing
Pangallo.
it's been removed?
Come up here.
Okay.
I'm just saying, look, if you look at, like, just you proportionally, here's the existing part of the house. This is almost as wide, right? A little shorter. So look at that portion of the house. If you were to make it slightly longer and superimpose it here,
Right.
it barely looks like there's room, and then a concrete patio.
Okay, so, I don't know, with these, I guess those trees maybe just look very sparse
But you see
right
what I'm
now.
saying? Like even this, look at how much it shows it goes out relative size. That doesn't even really look to scale, to be honest, you know, if you look at it, but leaving that aside. This out is almost as long as, you know what I'm saying, if I got the
So this
scale.
is showing
Look,
as-
if I go like
right.
this, okay, and I'm not denying it's shorter, right? But if I went like this, and if I, you know what I'm saying? Like it barely looks like it'll make it to here, and then how's the patio? I mean, it's not my problem, but I'm just saying. Do you see what I'm saying, though?
That he drew the wrong, like, this is not.
I don't know, I'm just saying, you see why it's like, we're talking about a 5-foot 10-inch here, and in that 5-foot 10-inch, he wants a patio, which I don't care, but it really does look like, let me just.
Sure.
I'm just saying, like, if I go like this, I say, if I compare this, that's 1 inch, to this is 3/4 inch. If I go this on that is 3/4, so let's say you have, all I'm saying is this, look, this construction is almost as wide as this part of the house, a little less. And if I go from that and stay a little less, it almost looks like it's gonna hit the trees from this view to this. And then there's a patio. I don't even know where that would be. I don't know.
In reality, when you actually look at the house itself, if you were to like rotate it, she has a picture of the backyard itself.
Actually do that.
You could get a street view too.
Yeah, no, that's what I'm saying. Right, yeah, that's a better look. So the trees go there, and then like every year or two, we basically trim them back to the.
Okay, yeah, that is a better view.
Yeah, so it looks from this, from the
I just raise it because that's the most extreme variance you're asking
Right,
for.
right, yeah.
And the question becomes like, that's significant reduction of the yard
Yeah,
there.
just. it's
Especially
like
since
where
it's
else
rear
can-
yard.
Yeah, there's nowhere else for them to put this. Right,
Yeah,
which
it's
is a
more like
secondary front yard.
it's such a significant variance, you know, to go from, 25 to 5.8, because that's not your side yard, you know? That's what made, and Ms. Green showed me this, and so we have to think about, is that a variance that is too significant? That's the only reason I was looking at it.
These corner properties.
To build a handicap accessible bathroom, we have to, she's completely.
Who's that?
And to do that, that's what's submitted to documents, and we have to waive it for residential law. Also sign
Right. I understand.
agreements, and that's why we're seeking this.
How long did it take to get this variance? All right, Stephanie, let the record reflect that the applicant and the applicant's representative clarified confusion as to the neighboring property that might be affected by the proposed variance.
Any other questions from the board?
I just want to read it.
Wait, did they put that on record?
What?
That
When
they
she
got the
admitted
state
it.
variance?
Yeah.
Yes.
Ready.
Any other questions for the board? If not, do I have a motion?
Move the hearing be closed, the matter be placed on the decision calendar. Ms. Pangallo, you and your client will both receive a copy of the board's decision by mail once it's
Second.
rendered.
Second?
Thank you very much.
All in favor?
Aye.
Any opposed?
Next, we'll be calling case 8425 Woodmere, Aaron and Michael Gordon. Variances, height, lot area occupied, side yards aggregate, construct dwelling, demolish existing dwelling, also known as 114 Oak Street.
What about me?
Hey, John, you want a old-fashioned lemon candy?
All right.
Oh, he works for the town.
Want to present a case?
Good morning, Mr. Chairman, members of the board.
Morning, Mr.
William
Benesso.
Good morning. William Benesso for Chelly Deegan Durana, 333 Earl Ovington Boulevard, Uniondale, New York, here on behalf of the applicants Aaron and Michelle Warren. With me this morning is Mr. Stanley Mayerfeld, the architect on the project for premises at 114 Oak Street in Woodmere. My clients are a married couple with 7 children and an ailing grandmother who's going to be residing with them soon. They are hoping to construct the home that has been proposed and presented to this board in terms of the plans before you. This is a parcel of property that is 75 feet wide by 150 feet deep in the Residence A district. They are seeking some relief in order to construct that home. They need a side yard aggregate and side yard variance from a technical standpoint. I'll get into that in just a moment. Additionally, they need a building coverage variance and they need a small height variance in connection with the application. When we first discussed this project with the architect and the clients, they initially wanted to do a 3-story home with 3 levels above grade, and I advised them of the position that the town takes in connection with those houses, and as such, they redesigned it so that it would be a true 2-story with attic space. But as you'll hear in a moment from Mr. Mayerfeld, we are seeking a 1.5-foot height variance to permit a overall height from the crown of the road of 31.5 feet as opposed to the 30 feet required. Before getting to that, with regard to the side yard setback and the side yard aggregate setback, the house itself is actually fully compliant from the standpoint of side yard aggregate and side yard setback. It is basically an architectural feature on the southerly side of the home. There's a proposed 10-foot wing wall with basically doors that open up that provide access to the rear yard. And then on the northerly side of the home, there's a 6-foot-high wing wall, which again, both are aesthetic and architectural features. They don't comprise the actual walls of the home, and they are there simply for the aesthetic on Oak Street. The rest of the home has an aggregate setback of in excess of 18 feet, actually 18.9 feet, or 18 feet 9 inches, with a minimum side yard of 6 feet 9 inches for the vast majority of the northerly side of the house. So again, the requirement for both a side yard setback variance and an aggregate are for the 2 aesthetic features that are proposed. In light of that, what you have is a proposed house that, although over the building area, is nevertheless fully compliant with the setbacks, front, rear, side, and side yard aggregate. So from the standpoint of the building area variance, which is 34.8% as opposed to the 25% permitted in the district, the proposed building coverage is 34.8% as opposed to 25%. It's the difference between a building coverage of 2,813 square feet and 3,917 square feet. Residence A. It's Residence A, which requires 25% as opposed to the 27.5 that you find in B. But again, what you have are setbacks that are fully compliant and do not trigger at least a visual difference that from the size of the house. Add to that the fact that rather than proceed as initially proposed with a third story, and instead do a true two-story with an attic, that resulted in a larger footprint for the dwelling. Now, I'm not going to say this is a small house. It's not. Obviously, you look at the plans, there's a great deal of space in the basement that is being used for a gym, for a recreation room and the like. But we are talking about a family with 7 children. They do have the need for all the bedrooms on the second floor, eight bedrooms plus the master plus.
But
plus
Mr.
7.
Benesso,
Yes.
I get some of it's architectural with that roof line. I forgot, is that a mansard roof or whatever they call that style? But that doesn't look like a small attic. I'm looking at the numbers. Okay, I get it. The finished attic floor is 48.69, so it is only about 8 feet to get to the top. But it's really looks like a 3-story house. Plus, you have the giant basement. But
Well, the height, and correct me if I'm wrong, Stanley, but I believe the actual height of the attic, roof, floor to ceiling, is 6 feet. Excuse me.
yeah, I say it could be because the finished floor is 48.69 and the ridge is 53. 56.34.
6'7" and a
Yeah,
quarter.
6'7" and a quarter. So
Right.
we're not talking about a tall area up there. It's not it's not even 7 feet. It's basically there for storage. It doesn't have stairs, regular stairs leading up to it. It has pull-down stairs. Is that correct? That is proposed. We would accept that as a condition. So it's not what you see on a lot of applications where they have a 8 or 9 foot quote-unquote attic that can be utilized. Yeah, the other aspects of the height variance, I want Mr. Merrifield to speak to directly, so if you would.
Yeah, and just to reiterate, regarding the coverage, like Mr. Benesso said, we actually had designed the house. They do have a number of children. We were putting some of the bedrooms upstairs as a 3rd story, and when we met, this was already like a year and a half ago. We made it a formal application, but Mr. Benesso said, this, not in this township. He advised us to take the bedrooms, bring it down, or have all the bedrooms on the 2nd floor. So that increased in our initial application. It was a smaller coverage, requested for a smaller coverage. And then we redesigned the 2nd floor, and we actually, if you notice the plans, the 2nd floor actually extends out past the 1st floor and the rear of the house, really to get those extra bedrooms. So it was a redesign to taking Mr. Benesso's advice. In terms of the grade, we're asking for, I think it's 18 inches, and the reason for that 18 inches comes about, if you look at sheet 87 rather, you'll see that we have the Crown of Road that's listed at 24.76, and the average grade at 26.21, which is roughly 18 inches. So because of that, and also by code, you have to, I think it's R317, we need to have our wood elevated out of the adjacent grade by a certain distance, just for moisture. Because of that, we're asking for relief for the additional 18 inches. But I also want to reiterate or to say very clearly that we're not changing the grade. If you look at the survey, the existing survey, these numbers of our average existing grade is at the property line. So this is the existing condition at our property and as it meets the neighbors. So it's going to be a very natural. We're not changing the grade in any sort of bit. So the ask of the additional height is due just to the natural change of grade from the Crown of Road to where the house sits.
Go ahead. Can I just ask you?
Sure.
I'm surprised. a lot of Woodmere is in the flood zone, and this is not only not in the flood zone apparently, but the Crown is at 24, almost 25.
Yeah, we have, it depends where you are, yeah. There's certain areas that it's very interesting. It's actually, as you get close to the train tracks, it's actually, that's a good indicator, like you want to know like where like you have like decent depth without water. That's where they're in that area. You go down a couple of blocks, yeah, it's a lot worse, but in that particular area, we got borings and we're okay with our height and as you.
Are those protruding structures into the air, are those actually chimneys or just for aesthetics?
We talking about, those are, I mean, they could be chimneys, but they're really part of the look of the home.
All right, and those are permitted encroachments, Becky?
Also in terms of, we had our, I could submit this as well, we had our perfect point, our surveyor go around and list other heights in the area in terms of heights. It actually,
We're gonna submit this. This is a ridge elevation survey that was performed. Go ahead.
if you want, I could, if it's clear for the board, I can mark off where we are, if it was marked off, like, so we have a. So you'll notice on the diagram that we just submitted, our ridge height is actually lower than the adjacent homes, if that's helpful. You're talking about context.
3 of the 4 adjacent
Yeah.
homes. The ridge height proposed is actually lower than 3 of the 4 adjacent homes. The ridge height survey that's being submitted indicates what the existing ridge height for 3 of the surrounding homes on the same side of Oak Street are.
You know?
I can't
Roughly,
say.
in the last 10
Well,
years?
one is relatively new. 2 doors down is a house very similar to the one being proposed here. I got to believe that was probably in the
Yeah.
last 5 years.
Yeah.
That's the only one that's not higher than his.
No.
130 Oak Street?
The
that's-
adjacent neighbors are older homes. They have, I haven't been to their homes, but you could look up, you can see there are windows, there's attic space. I'm assuming there's attic space. I know the current house also has attic space. But you are correct that it is, they're older homes. They're original homes. Most of them are original homes. But again, the relief, the reason why we're asking relief for the 18 inches is due to match the 18 inches that the property naturally grades up from the street. And as we know, like we have to measure from the crown of road. So there is that differential of 18 inches. Had this been like a different street where it kind of sloped down, then obviously we wouldn't need relief. If you look at the building section as well, where the finished building, the finished floor height on the first floor is going to be 9.5 feet, then on the second floor, it's going to be 8 feet. So we're not asking for like towering ceiling height.
Are there fireplaces in the house, proposed to be?
Are you talking about the chimneys?
I'm just asking you, are there fireplaces?
There'll also be a number of fireplaces. We also have one on the first floor, you see by the living room, dining room. And maybe one in the library as well.
There may be one, or there isn't?
Yeah, I mean, we're in discussion,
Yeah.
Assume yes. Assume yes.
The chimneys look like they're decorative, not
Yeah.
necessarily hooked
Yeah,
up to
no,
a...
they're stacked over there. I mean, our intention is to put like, they fall in like natural places. In the library to have a fireplace over it, or one fireplace.
Would they be attached to those chimneys that you're showing?
Yes, but, yeah. They fit exactly right in that spot. Should show them in a floor plan. It's helpful to lower the chimneys a bit just to make it to code. Have to see what I don't have a number in it.
If those chimneys are not going to be attached to a fireplace, they're not allowed. It would be a decorative.
Understood.
Okay, and you'll
Understood.
agree to it that they will be attached or
Yes.
removed?
Or removed,
Still?
yes, correct, yes.
Okay.
Understood. I understand what you're saying. The permitted obstruction is allowed for a working actual fireplace. If it's just a decorative fireplace, then you would not be able to get that.
Exactly.
Or heating system. Understood.
Good, thank you.
All right. Is there anything else you wish to add, Mr. Benesso?
No, I think the combination of the grade and the ability to maintain that first floor wood out of the ground is the main reasons for our request. And we have tried to keep the ceiling heights down to not excessive numbers. As he said, we're not talking about 10, 11-foot ceiling heights. So
Or even 12.
we're certainly,
In fairness, there is the first floor that would give you the 18 inches back if you had an 8-foot ceiling, but that's,
you know these homes as they're being built today now, so.
yes. And I will say that the elevation map was quite helpful, because I wouldn't have believed those numbers had I not seen it there. Okay, is there any other questions from the board? If not, do I have a motion?
I move the hearing be closed, the case placed on the decision calendar. When the board renders its decision, you will be notified.
Thank you very much.
Second?
Second.
All in favor?
Aye.
Have a nice day, folks.
Thank you. Thank you so much.
You're welcome.
Break. Okay.
I'm going to go back to the prior page, Patrick.
Next, we'll be calling case 8025 Baldwin, Adeline LaRose. Special exception to maintain a second accessory structure, shed, higher than permitted and exceeding horizontal maximum, also known as 1016 Thomas Avenue.
No, he skipped because of that guy. Oh, Woodman, which one? Yes, we're on case 80. Yeah, we did. Yes.
My name is Adeline LaRose. I live in 1016 Thomas Avenue, Baldwin, New York, 11510.
Okay, do me a favor. Will you tilt the microphone a little down so you can speak directly into it, and speak as loudly and slowly as you can, because the court reporter has to take it all down. Okay, and you are here because you have a second accessory structure known as a shed, and that shed is higher than it's allowed to be, which is 9 feet is allowable, and it exceeds the length on at least one side. So I'm just going to ask you, based on your materials, I guess your first accessory structure is that gazebo you have, and that is not before us. So that must meet the height requirement. I'm surprised, but okay. The second accessory structure that is before us is a shed that is 10.5 feet on 2 of the sides, and 2 of the sides are 12.3 feet, where 12 feet is allowable. So on those 2 sides, you need a variance for 0.3 feet. So it's a relatively de minimis difference. You need the special exception because it's your second structure. And then let me find out. Do you happen to know the height of the shed at the tallest point?
So I'm sorry, I didn't know. I purchased the home not too long ago. I didn't know if the shed is a very big deal. I'm sorry for that.
No problem. Let me just, good. Mr. Pellegrini, as always, has found that the shed height, according to the shed diagram that was submitted in the file as part of the record, it shows that the overall height of the shed is 9 feet. It's either 9, it looks like 9 feet 6 inches, where
Yes.
9 feet is allowable. So it's also a relatively de minimis request.
I heard about it. It's 6 inches over, but I didn't know it's a big deal. I'm sorry.
That's quite all right.
Yeah.
So, other than these relatively de minimis requests, you have no other requests before the board, so I think we understand the case. Is there anything else you'd like to add?
No.
Okay.
Thank you.
Are there any other questions from the board? If there are not, may I have a motion?
I move the hearing be closed, not placed on the decision calendar. You'll be notified by mail of the board's decision once rendered.
Second? All in favor? Aye. Okay, you're finished. You will get a copy of the decision in the mail, okay? Have a nice day.
Madam Chair?
Oh, I'm sorry, Stephanie? No, I think we should take it now. If you're gonna need a break in the next half an hour, let's do it now. We're just gonna take like a 10-minute break so the court reporter can rest her hands.
Chris, I feel like I'm sitting in a hole.
I do
Yeah,
too.
sinking. They did.
You okay, Steph? All right, go ahead, Patrick.
Next, we'll be calling case 8125, Baldwin, 1725 Conway Street LLC. Variance, front yard average setback, complete construction of dwelling with garage on existing concrete foundation, also known as 1116 Washington Place.
Yes. Good morning, Mr. Chairman, members of the board. Appearing for the applicant, Howard Avertine, 2116 Merrick Avenue in Merrick. This is the application of 1725 Conway Street LLC for a front yard variance. The premises under application is located on the southerly side of Washington Place, 200 feet east of Eastern Parkway in Baldwin. It has a street address of 1116 Washington Place, and it's also known as Section 54, Block 359, Lots 722 through 724.
Mr. Albertine?
Yes.
May I just ask you, why is it noted as complete construction of the dwelling?
Because, well, I was going to get to that, but I'll answer out of order. A permit with a variance was granted back in 2021, creating this parcel and the adjoining parcel, which is a 40-footer. And so, other than the need for a subdivision, this is a conforming lot, and the proposal back in 2021 was for a fully conforming development.
60 by...
60 by 100 and all the required setbacks and no height, no lot coverage, nothing. But the contractor that installed the foundation put it in the wrong place. He put it 5 feet further toward the street, so creating, rather than the 25-foot compliance setback, put it in at 20 feet, hence the need for the variance. That was discovered only upon inspection by the town during construction of the home.
Do we think he put it there because the homeowner asked him to?
I would hope not. The architect submitted a letter, which is part of the file, indicating that it was an error. I have no reason to doubt that that is the case.
Does the builder also build in East Rockaway?
That I don't know, sir. But I would say here that fortunately for this applicant, when I inspected the property from the street view, one really cannot tell the difference between this house and the other home that is being built right next door to it in terms of the relative setbacks.
Mr. Avertine?
Yes.
Did anyone ask the builder what happened? And can we know that if you do?
I can only say that I've been advised that it was the contractor that did the pouring of the foundation made a mistake, and that from what has been told to me, no one realized it from the builder's side of things until the town inspector picked it up during the foundation inspection, and stopped the job, and hence started this thing. I would only say that if that was done, if this whole thing was done purposefully, it would not make a whole lot of sense, only because it stopped the project, incurred all sorts of additional fees,
right, but I mean,
lost a lot of time in having to rectify the situation.
Yeah, I'm just curious, when it was discovered, I assume your client went to the contractor who poured the foundation and said, you know, what the whatever, and I was just curious what his response was, like, ooh, I couldn't read plans, or?
I think he was aghast. From what I am told, again, this is from someone
Double
telling
hearsay.
me, that there was a bit of accusations in more than one direction, the contractor claiming it was the surveyor's fault, these types of things. Okay. But regardless of whose fault it was, this is the situation, and the applicant finds himself in a position of appearing before this board to seek relief or bear the quite expensive alternative of having to knock down what's there, remove the foundation, and redo the whole thing, which is
So-
literally tens and tens of thousands of dollars.
Is it only still sitting there with a foundation, or have they?
No, the house has partially been constructed. I think the photos depict that.
So if the inspector of the foundation is the one who discovered it and it had to stop then?
I believe so. Again, I'm relatively new to this entire situation. I don't know at what point that occurred.
Oh, it's almost, the house is built. Oh, so it wasn't stopped when the foundation was poured. Doesn't the foundation have to be signed off on?
The plot thickens.
So you mean when you pour a foundation, you can continue building even if you're,
Say boo-boo.
which they waited quite a while because the whole house is built and roofed and sided. But, okay, got it.
I would like to point out, though, that the average front yard setback is 24.58 feet with the 20-foot that is provided. If you have a moment to take a look at the radius map, which sets forth... on
Mr.
the
Aberdeen, can you say that again? The front yard average in the area is 20 point,
The average is 24.58. And
Okay.
originally, 25 was depicted. And 20 is what we are now seeking approval for.
So the board approved a 25-foot setback.
Well, it
Didn't
was,
even need
it was as of right.
Okay.
So that was it was a compliance.
the whole house was as of right.
The whole house was as of right on the 60 by 100. The only
Understood.
reason it was before the board was because it was part of a subdivision,
Okay.
the parcel directly to the west. Now, if you take a look at the radius map, which depicts the front yards on the southerly side of Washington Place, you'll notice that the home directly to the east of the subject has a front yard of 42.2 feet. The remainder within the 200-foot radius, with the exception of one, actually, have, if you're moving to the east, you have lots 716 and 717 at 21.1 feet, 714 and 715 at 21.8 feet, 712 and 713 at 22.3 feet, and then to the west, you have the home at it's lots 727 and 728 at 14.5 feet. So it is really that house that's 42.2 that skews the average and really requires it to be a greater setback than the area character really dictates. So I would respectfully submit to the board that 20 feet is not out of character for the area and will not result in any adverse impact.
Are you familiar with the original plans that was approved as of right to the building department?
You mean the building plans?
Yes.
I have them, yes.
Have you compared them to what is built now, and are they the same? Does
To
this-
my knowledge, they're the same.
Does this need possibly a height variance, because it's pretty damn tall?
Well, I would say this. The plans, from what I've seen here and reviewed, it's the same house. It's just a question of the the front yard setback. Let me take a look at the elevation. It shows it at 28 feet 10 inches as the from design flood elevation, so, and it has a crawl space below. So apparently, it's been found by the building department, maybe,
Mrs. First.
yes, Ms. First can address that.
Good morning.
Mr. Pellegrini is asking whether the building is height compliant. I indicated that the,
Property's located in a special flood hazard area, so that may help why I look to see if the,
it's, according to the drawings, it is 28 feet 10 inches from design flood elevation to the ridge, which would make it compliant.
Stephanie?
Assuming that's all accurate, which I can't, it's signed and sealed. These plans were approved by the building department prior to issuance, obviously, of the building permit that was subsequently stopped because
Stephanie?
of the error.
Do you take Ms. First down on the record when she speaks? Okay. So make sure you use the microphone, Ms.
sorry.
First. You know, so that we
Yeah.
have it, and you have her full name, et cetera, right?
the property is located in a special flood hazard area and is proposed to be 10 inches above the design flood elevation. The design flood elevation looks like it is to about 6 feet above the crown of the road, so it's gonna look high.
At what point is it now under re-review, if at all, with the buildings department? In other words, somebody caught that the setback was wrong.
So during the location survey, we're looking to see where the foundation is and the setbacks for the property. Once the framing is complete, we call the surveyor out again to shoot the ridge to see the height.
And has that been done?
Not yet, because we're waiting for this portion. And the reason being is if it turns out it is over height, if they're only up to framing, that could be something that can be corrected into the field
Right.
and doesn't require a variance.
So this builder didn't follow the
It's not through the
timely
steps yet,
procedure.
correct.
Ms. First, Ms. First, does the building department, in its following of the structure, have, for example, the name of the contractor who poured the concrete? Is that part of the record in the building department?
Usually not, it's usually a sub-trade, so the overall GC would be listed, so we would not have. But most likely, when a situation of this occurs, it's usually surveyor error that usually comes into account, because
Don't they just work from the survey that was
No,
looked at?
the surveyor comes out and posts exactly where they're supposed to pour and where the frames are supposed to be placed. So therefore, the surveyor most likely made an error when he was staking out the location for the foundation.
Do we know, do we know who the surveyor was on this piece of property?
I don't think
Is it
he's
somewhere
asking
in
you
the
who it
file?
was, I think he's asking you if we know who it was.
No, I want to know the
You want the
identity
name?
of the surveyor. Why not? I'm allowed to do that.
I'm not sure who the surveyor was. I have
think he- oh, go ahead.
sealed drawings, but we could find that out easily enough.
I think Ms. First is seeing if she has. Is it usually the same one who drew it, or do they often use a different one?
It could be either one, but usually it is the same one that did the original proposed survey.
You know, Mr. Avertine, our obvious concern is, this is not, is the precedential impact. I get your argument that it could appear relatively de minimis for all other purposes, but there's always the concern that if this becomes the standard, one can't help but notice, is it a coincidence that it got poured in the wrong place, and then they built the whole house before it was inspected?
I understand what you're
Yeah,
saying.
I mean, I'm
can't
not
speak
suggesting your
directly to
client-
that, but I would also point out that the setback is, the 20-foot setback is to the roof over porch. The actual home is set back 25 feet.
No, I
even though-
understand. That's my point is, while it doesn't look like it's going to have a significant impact on community, et cetera, if you just come to us for this, my guess is it would be easily granted. The concern we have, because we've started getting, this isn't the first one we've gotten recently, is are we incentivizing people to, fudge it here and there, delay the surveys a little, and then come and go, it's too expensive to change it. And I'm not suggesting your client did that. It sounds to me like this was probably a very legitimate error. But, everything we do, we hear about later when the
Understood. The only thing I can say to that is anyone, at least in my experience, anyone who is in this business, any builder, would not go this route and lose all the time and have all the additional expense to
I agree.
gain the 5 feet. I would have asked for the variance in the first place.
Right, but if we had approved 25 of these cases over the last 2 years, people would rely on that and say, hey, look, I want it over there, let's do this real quick, and then we'll just have to go before the board, and what are they gonna do, make us, people have said, what are they gonna do, make us tear it down? You know what I'm saying? That's not the case right now.
Understood.
I'm just trying to say, as an attorney, you know a little bit about, I mean, you know what I mean.
Sadly, yes. But I don't believe that that's the case here. I do believe it was an honest error, and in my discussions with the applicant, he was quite distraught over the entire circumstance, and especially since I don't know what the financial arrangements are between him and the contractor, but I suspect that the delay and everything else in terms of the expense and the time and the aggravation
Your other litigation related to
was
the
not,
transaction.
was not worth it, if that was the case.
It was Buckley, All County Land Surveyor, PC, in Flushing, New York.
Ah,
All county,
All County Land Surveyor
Buckley.
in
Buckley.
Flushing, New York.
Thank
all
you,
those people in Queens.
thank you. Anything you'd like to add, Ms. Robertine?
Nothing further, Mr. Chairman.
Any other questions from the board? Go right ahead.
Mr. Abbott, hi.
Yes, sir.
You put on a very good case, you know, as the representative of these people, but to me, the facts of what happened seem very sketchy at best. And it bothers me that, you know, no one along the chain, there was a lot of time that we could have caught this supposed mistake. And what bothers me the most is that they didn't get the foundation inspection before they framed the house. And, you know, looking at the pictures at this point, I'd like to know how tall it is at this point. You don't know really how tall it is because you didn't measure it.
I think you do.
Well,
think-
I certainly
you do.
am working under the belief that the home, other than the fact that the foundation was poured in the wrong location and that the house will be further forward than it was approved to be, that everything else will be in compliance. There are revised drawings which depict the sole change between what was originally approved and that which is before the board today is solely the front yard setback. Everything else is identical.
But why would the contractor, if he's a reputable contractor, start framing the house before he has the foundation inspection? That's my question.
I don't
Can't
have the
answer that.
answer
No, because
there.
that's what bothers me. I'm
I-
not saying legitimate mistakes can't be made.
No, understood. It could have been weather-related where they unfortunately.
Don't speculate. No, don't
Understood.
speculate.
I'm just, you know, making, you know.
Yeah, I
that's
hear
why
what
I'm-
you're saying, and I understand your
My
concern.
thoughts.
I would still respectfully argue here that in conducting the balancing test, on balance, the benefit is outweighed by any detriment, in that there really is no detriment. It's the same house that was going to be originally, just a little bit further forward, and that's minimized, the impact is minimized by the fact that the encroachment is solely in the form of a covered entranceway to the home, not part of the house itself.
If we do vote to grant this variance, can you give us your word that you'll get your client to get all the inspections on time, whether it be electrical, whether it be plumbing, whether it be whatever else needs to be done?
I will.
Without, you know, without going ahead, not building it and then finding another violation.
I can represent to this board that I will strongly admonish the applicant going forward to make sure everything is done in the way that the town requires it to be done and in the way that the building department requires, so that everything is done properly. Absolutely, sir.
Thank you.
I have one further comment.
Yes.
Should the board approve this application, I am going to suggest to my colleagues that it be limited only to the front yard setback and not in accordance with the plans that were submitted, limited only to the front yard setback.
just so I can clarify what you're stating, Mr. Pellegrini, that essentially the house must be in compliance with every other aspect of the zoning ordinance other than the front yard setback that we are speaking about here this morning.
Yes.
So irrespective, in other words, what, in the vernacular, don't come back asking for more later.
Yeah.
I got you. Just wanted to make sure that's what you were getting at.
Yes, and, I mean, as you know, overall, the board grants an application in accordance with their plot plan and plans. This is not going to be granted in accordance with the plans. Only the front yard setback as it exists today, and not the entire house.
Understood, because, well, again, to my understanding, the plans, and I understand your point, and I'm not quarreling with it, but the plans were reviewed by the building department, and the building department only rejected the plans that are before you based upon the
Okay.
front yard setback.
Well, then it should be a home run.
I'm not saying no, I just wanted to make sure that that was clear for the record.
Thank you.
Thank you.
Close the case. Go ahead. You're in trouble.
That concludes your case, Mr. Avertine?
Yes, sir.
Any other questions from the board? If not, do I have a motion?
Move that the hearing be closed, the matter be placed on the decision calendar. Mr. Avertine, you'll be notified by mail of the board's decision once it's rendered.
Thank you very much.
All in favor? Aye. Any opposed? Let the record reflect the fact that I'm recused on the next three cases.
Okay. Next, we'll be calling case 8525 Roosevelt, New York Land Development 2 Corporation. Variances, a subdivision of lot area, lot width from and on street line, the front setback line, lot area occupied, construct new dwelling with garage, lot A, demolish existing dwelling, formerly known as 123 Frederick Avenue. Case 8625 Roosevelt, New York Land Development 2 Corporation. Variances, subdivision of lot area, lot width from and on street line to front setback line, lot area occupied, construct dwelling with garage, lot B. North side of Frederick Avenue, 241.67 feet east of Stevens Street. 8725 Roosevelt, New York Land Development 2 Corporation. Variances, subdivision of lot area, lot width from and on street line to front setback line, lot area occupied, construct dwelling with garage, lot C, north side of Frederick Avenue, 283.33 feet east of Stevens Street.
Yes. Yes. For the applicant, Robert W. O'Brien, 877 North Corona Avenue, Valley Stream, New York, 11580.
There are other folks that signed in. Why don't you come up and sit in the front here so they could hear?
Jed Nelson,
Just a minute.
1380 Belmore Avenue, Belmore, New York.
James Bianco, New York Land Development, 1136 Arlington Avenue, Franklin Square.
Come sit up front. It's okay. I mean, it's easy.
If
You're welcome to sit up front.
And if you're going to, if you intend on speaking at all, if you want to sit on that side, you'll be nearer to the podium, which is where you'll speak. It's up to you, but you can hear better, you can see, we can show you exhibits if they have any, et cetera.
Et cetera, et cetera.
Good morning.
Good morning, Mr. O'Brien.
D'Amato and members of the board. I again represent today New York Land Development 2 Corp. with respect to the instant application for a 3-lot subdivision in the hamlet of Roosevelt. At the outset, I would like to move to have the 3 cases consolidated and heard as one. Thank you. To my right is real estate expert Jed Nelson, who's prepared to testify regarding the nature and character of the area and that the benefit of the application. to the applicant outweighs any detriment to the surrounding community. And to my left is the applicant's principal, James Bianco, to answer any questions the board may have regarding the application. The property that is the subject of the application is on the north side of Frederick Avenue in the hamlet of Roosevelt, approximately 200 feet east of Stevens Street. And just for the record, it's known on the Nassau County tax map as Section 55, Block 313, lots 312 through 316. The parcel as it exists is a perfect rectangle with 125 feet of frontage on Frederick Avenue, 100 feet of depth on each side, and rear property line of 125 feet. Therefore, has an overall area of 12,500 square feet. It is currently improved with a one-family, dilapidated, boarded-up dwelling and detached garage. Mr. Nelson has some photos which he's going to submit to the board as part of his presentation so the board can get a flavor for what exists there now. The applicant proposes subdividing the property and then constructing 3 new one-family dwellings with attached garages on each new parcel. Each parcel will, well, be technical. Two parcels will have 41.67 feet of frontage. The middle one will have 41.66 feet of frontage. So you have 2 parcels with that will have 41.67 square feet, and the middle parcel with 41.66 square feet.
Not square feet, width.
Square feet. I'm 4,167 square feet. But I know where you're going, Mr. D'Amato.
No, didn't you
The
say-
frontages are 41.67, 41.66, and 41.67.
Okay.
Time, well, that's square footage.
So what was the square footage number you were giving us?
4,167, 4,166, and 4,100. I knew you would call me on my math, so I wanted to be specific.
Yeah, no, I thought you were just reiterating front width, but it so happens the square footage is.
Okay. So the variance needed to subdivide the property and construct the 3 proposed new homes, and also for the demolition of the existing structures, is for permission for the subdivision itself, lot area front width from and on street line to the front setback line, and lot area occupied. As is my practice, I made a visit to the property, did an inspection of the surrounding area. The homes, for the most part, and this is more for Mr. Nelson, but as I always tell the board, I always like to go out and look at the area so that if they ask questions, I can report accurately to the board. The homes, for the most part, are on the older side, capes from the 60s or so, and generally in good repair and maintained well. This is the only quote-unquote disaster that I saw in the surrounding area. Right across the street, the board will notice, is a church property that has some vacant land adjacent to the east in which a couple of buses were parked when I did my inspection. It doesn't appear to be too active, but I went during the week, not on when services would normally be conducted. There do not appear to be any residential properties in the 200-foot radius which could be similarly subdivided. And unless the board has any questions of me at this time, I'd like to turn it over to Mr. Nelson, then to the community, because I know there's interest in the community. I think in favor. I don't want to speak for everybody who's here, and then I'll sum up and answer any questions the board may have.
Mr. Nelson, since you last appeared before this board to give expert testimony as it relates to real estate and real estate valuation, have there been any change in your credentials?
No, ma'am.
Okay. Then you are qualified to testify as to those matters before this board.
Thank you.
You were sworn in as a group? You were sworn in with, you already sworn in?
I'm sorry?
You were already sworn in?
Yes.
Okay. Don't forget to give your name and address.
It's already in the record.
Go ahead.
Thank you. I've prepared a package of photographs. This package was submitted to the zoning board and I believe uploaded to the application about a month ago, but I'd like to submit the hard copy for the board if they care to peruse it. In addition to the photographs, there are approximately 14 variances that were granted within a 4-block radius.
Hold on,
of-
hold on. Dawn, can you hold on for just a second? Two things. Did you take the photos?
The photographs were taken by me. I'm sorry, it's dated on there.
Okay, and do they fairly and accurately represent what they purport to represent? They've not otherwise been altered?
Yes, ma'am.
Okay. Can we show it to the interested folks? Okay. We'll accept it into evidence.
Thank you.
Go ahead.
I have also prepared an exhibit, which is a radius map. The radius map bears colors and legends of properties in and around the subject property within approximately a 200-foot radius. There's a legend that indicates what different colors represent, as well as my handwritten notes as far as what comprises the 100-foot radius and the 200-foot radius, as well as the properties on the subject lot.
Okay, we'll accept that into evidence. You said we also have a photo array in here, because I'd also like to look at it as you testify.
Yes.
Give me just a second to find it. Not my strong suit. No, I'm letting the other folks who are here. Mr. Nelson, you said that you uploaded and you also brought up hard copy?
No, I did not upload it. The zoning board downstairs requested me to provide them with an original, and then they would upload it.
So you
So
gave
I-
us a hard copy?
Correct. And it has to be a month ago.
All right, I guess I want to let those folks continue to look at that one. All right, why don't you go ahead and hopefully we can
You
get one
can't
in.
find it?
Not right yet. It's not my
Okay.
strong suit, finding things in the files, but we're looking. But go ahead, I don't want to delay it. Go ahead.
Okay. The subject property, once again, is located on the north side of Frederick Avenue, approximately 200 feet west of St. Francis Street, in the unincorporated hamlet of Roosevelt, part of Nassau County, New York. It's designated at Section 55, Block 313, lots 312 through 316. It is zoned Residence B by the Town of Hempstead Building Department. The subject property affords 125 feet of street frontage along Frederick Avenue with 100 feet in depth, containing a total of 12,500 plus or minus square feet in total land area, making it one of the largest lots in this area, except for the Calvary Baptist Church property located directly across the street from the subject. The applicant is proposing a 3-lot subdivision with each parcel affording approximately 41.67 plus or minus feet of street frontage and containing 4,167 plus or minus square feet in total lot area. Proposed for each site would be a modest 2-story colonial-style dwelling containing just under 2,000 square feet of livable area with a 1-car internal garage and a paved parking site out front suitable for an additional 1 to 2 cars.
Slow it down a little bit, would you?
Oh, okay.
Thank you.
I was
It's okay.
told I had to make this short.
You can make it short, just make it slow, too.
Understood. The proposed development will be in keeping with the existing neighborhood developments and will not alter the existing characteristics in this area. Within the 100-foot radius of the subject property, there are 13 residentially developed lots excluding the church, of which 11 of the 13, or 85%, are substandard lots based upon the Residence B zoning requirements. All of the 11 are 50-foot frontages and contain approximately 5,000 plus or minus square feet in lot area. All would require variances if they were developed today.
They were developed prior to the change in the ordinance.
Noted on the radius map, they were developed subsequent to, or to 1955.
At that point, the requirement for Residence B was,
Top of my head, 50 by 100?
that's what I would say.
Okay.
So these are all legal houses.
As of the time they were built, but would require variances based upon today's
Not
requirements.
substantial.
To answer your question, yes.
Right, a little less substantial variances, but I understand.
If they, yeah, if it was demoed and rebuilt today, they would require the 6,000 square feet. However,
Correct.
they are legally there.
Yes.
On the subject parcel, was there a house there? Two
It
houses?
is still there. There are pictures.
One house or two houses?
One house, it's a wide line Cape Cod with a two-car detached garage
And that house is legally built and,
on a 125-foot wide
Yes.
lot, yes.
thank you.
Within the 200-foot radius, there are 36 residentially developed lots, of which 21 of the 36, or 58%, are substandard based upon the Residence B requirements of today. On the subject street, within a 200-foot radius, excluding the church property, there are 13 residentially developed lots, of which 10 of the 13, or 77%, are substandard in lot area, street frontage, based upon the present Residence B zoning requirements. The properties abutting the subject property to the east and to the west are all substandard in size based upon the present Residence B zoning requirements. The proposed development pursuant to the application, in my professional opinion, offers a substantial upgrade to what was previously there on this property and would offer a nice complement to the well-maintained homes on the block and in this area. Perhaps it would be an incentive for the church property to enhance the maintenance on their property.
Mr. Nelson, two of this, it looks like two of the lots, three of the lots to the west on the street are not substandard? Did you say all of the ones to the east and the west of the subject property?
No, I said the properties abutting the subject to the east and to the rear
Yeah, because to the west, it's
Is
not a
a-
substandard.
is a 50.
No, no.
Excuse me, is a 60.
Right, it's not
Then
sub-
there's a 20-foot vacant lot.
Correct.
And then there are two other 60s, correct.
Okay, so to the west, to the east, yes, to the west, okay.
To
Go
the
ahead.
east, we have three 50-footers. To the rear, we have 1, 2, 3, 4, 5, 6, 7 50-footers.
You can continue.
In my professional opinion, I do not believe the reduced lot sizes as proposed herewith will present any detriment to the neighbors, the neighborhood, or any nearby properties or property ownership. In the rear of the package of the photographs I submitted, there are 14 variances which were granted within a 4-block radius of the subject property for diminished lot area and/or street frontage. Based upon those developments and the prices of existing homes in this area, including recent developments in the area, are at an all-time high. Evident that there is no detriment to home prices, values, character of neighborhoods, or a negative impact by a lesser lot variance request.
Mr. Nelson, did you do any comparison as to lot coverage?
I did not. It is my professional opinion that by granting the requested variances proposed by this application will not adversely affect the existing property values, nor will it have any adverse impact on the marketability of any existing homes in the area. It will not have any adverse effect on the quiet enjoyment of any nearby properties, property ownerships, or the community. All utilities are readily available on Frederick Avenue, including gas, electric, water, cable services, etc. Each proposed developed site will provide for on-site parking of between 2 to 3 automobiles. Existing homes in this area are selling between a low of $300,000 to a high of well over $700,000. New constructions in the area are selling from a low of $700,000 to a high of almost $800,000. The anticipated selling prices of homes which are the subject of this application are estimated to be in the low 700s to the mid $700,000, certainly towards the higher end of the value range for the neighborhood. In my professional opinion, the proposed application makes very good sense, offers a good solution in aiding the housing shortage that we are in the midst of. As of yesterday, according to the Multiple Listing Service of Long Island, there are 23 homes for sale in all of the 11575 zip code. That is Roosevelt, yes. I'm sorry, yes. Thereby demonstrating that there is a need for housing. 23 houses. And in my experience, I've been a broker for almost 20 years. I've been appraising for 41 years. A healthy, normal real estate market where it's not in the favor of the sellers, there should be between 200 and 300 houses for sale in any given community at one time. So, well, there are, believe it or not, but 23 houses makes this, you know, a seller's market, and there's such a shortage. That's basically my presentation. If the board has questions, I'll be happy to answer as best as I can.
As of right, you can construct 2 houses.
Yes, we have 125-foot of frontage, so it is 60.
And what would be the, Mr. Nelson, what would be the financial detriment if only 2 houses were to be constructed?
I have done economics. A 2-lot subdivision compared to a 3-lot subdivision is substantial. I would estimate $200,000 to the recognized loss in profit.
Okay. Doesn't look like anyone else has any questions at this time for Mr. Nelson.
I know there were several people
Right.
signed up. I know Mr. Boyd came from the Chamber of Commerce.
Right, are you done at this time?
I'll respond when everybody's done. if I may, Ms.
Okay, those of you who are here to speak on this matter, it looks like there are 4 of you. I'm just going to call you in order of how you signed in. So the first one is Mr. John Boyd, President of Roosevelt Chamber of Commerce. And if you want to come to the podium here, sir.
20% deviance required.
Let him.
John F. Boyd, Sr.
Is he wishing to
34
submit
Lee
that
Street,
into evidence?
Roosevelt, New York, 11575. I'm not sure if it's morning or evening, it's afternoon, let me see. Oh, it's afternoon. Good afternoon, Town of Hempstead board members.
Should I admit it? No, I want him, one moment, sir. I just want him to tell me what it is on the record so I can admit it. That way we'll have the transcript to track through it.
We have copies, so I'll pass these out.
Okay, sir, you have a document here that you wish to admit into evidence, and give one to Mr. O'Brien,
That is correct.
and give one to Mr. O'Brien. And this is a letter to the town of Hempstead from the Chamber of Commerce in Roosevelt?
This is correct.
Okay, and this bears your signature, dated February 3rd, 2025, and it has with it some photographs. Are those photographs that you took, Mr. Boyd?
That's correct.
Okay, and they fairly and accurately represent what they purport to represent. They weren't altered in any way, correct?
That's correct.
Okay, we'll accept that into evidence. And you can go ahead and tell us what you'd like us to know about this project.
I would like to read my letter out loud to the board.
Okay, sir, go ahead. Do you have a copy of it?
Yes.
Go for it.
Stephanie, would you like a copy of this to assist you? Okay.
We'll give you one after.
On behalf of my community, I want to say good morning to the board, and we want you to highly consider approving this proposal. The Town of Hempstead Board of Zoning Appeals letter recommendation for cases 85, 86, and 87. Can y'all hear me all right? Or
We can.
I think folks- okay. Dear Board of Zoning Appeals, my name is John F. Boyd Sr., and I am the president of the Roosevelt Chamber of Commerce. I have been made aware of a request for a special exception variance for the proposed development of the property located at 123 Frederick Avenue, Roosevelt, New York, by New York Land Development 2 Corp. The board may not be aware of this, but our town of Roosevelt is only 1 square mile, and our Roosevelt Chamber of Commerce is always concerned about what kinds of buildings are located in our community. However, we still want to encourage our residents and business owners to come to our community and to continue working on establishing their own properties in our town. 123 Frederick Avenue is located on the northwest side of Frederick Avenue, about 1,000 feet from our most prime business district on Babylon Turnpike. The location of this property will help grow our economy and will provide the necessary additional housing that we truly need for our local residents. The Roosevelt Chamber of Commerce realizes that this property must be brought up to Town of Hempstead building codes by the issuance of this variance, and after reviewing the proposed plans that were presented to the Roosevelt Chamber of Commerce, we are in full support of this request from New York Land Development 2 Corp. For the separation and new construction of the old 123 Frederick Avenue location as it is contained in cases 85, 86, and 87. We submitted pictures to show you what is currently there.
Yes, I see those.
And people from the community has spoken to the chamber, and they want this site improved. And we have nothing but good things to say about New York Development Corp. I think I was here to help support them on a project on Underhill Avenue in May of last year, and they did such a wonderful job. Everybody had nothing but good things to say. So on behalf of the community, the Chamber of Commerce, we would like for the board to truly consider approving this variance. I know it's going to take some work to get it done, but you won't have the opposition for anybody from the community.
Thank you, sir.
All right, thank you.
Okay. Going down the list, the next person I have is, pardon me, Jillian Rose. Oh, we can give this one too. Thank you. Hey, can you give this to Stephanie? Give it to Stephanie, she can keep it.
My name is.
Good morning.
Good morning. My name is Jillian Rose, 250 East Greenwich Avenue in Roosevelt. Good morning. Or is it really? Okay, so I am a homeowner in Roosevelt, and I believe that this project should go forward to make it look better. It looks bad right now, and I believe that with the development of this project, our neighborhood will look nicer. And it will also promote home ownership, new home ownership, and I think that'll be a good thing for the community. Thank you.
And was your client intending to make these, will agree to make these owner-occupied residents?
As part of my closing, the answer is yes. My client will agree to a condition that all 3 homes, if approved by the board, that there be a provision in the covenants and restrictions requiring them to be owner-occupied.
Perfect.
As well as no exterior basement entrance.
Absolutely. If there is on the plans, remove it because...
They are on the plans.
Then we consent to the removal of those from all 3 proposed new homes.
Thank you. Ms. Rose, anything else you'd like to tell us?
No, thank you.
Thank you for taking the time to come in and...
Ms. Rose, I have a question.
Absolutely.
they can, as of right, develop it with 2 houses instead of the 3. They need us for the 3rd house.
Right,
You understand that?
I do.
Thank you.
Thank
Okay,
you.
thank you, ma'am. Next, we have Deshaun Burrell.
Dejan Burrell, 20 Gusto Avenue, Roosevelt, 11575.
Good afternoon, Mr. Burrell.
Chairman, to the board.
Good afternoon.
For this opportunity. I too agree and certainly concur with the idea being that the development of said property would bring an aesthetic improvement to the community. Also because said property sits before a fire hydrant and certainly immediately across from a religious establishment, certainly will enhance the living environment of said community. Be it now the property is not so aesthetically warming, and again before a fire hydrant, which per my view saw debris surrounding it and making it not so accessible, certainly in lieu of what has taken place in the boroughs, be it the Bronx and Brooklyn, certainly on our west coast in Los Angeles area. We want that property developed and certainly to be make it accessible to the health and safety of the community. Thank you.
Thank you, sir.
Pleasure.
Okay, last but not least, we have, I think it's Maria Marcy Mombrun. 120 Frederick Avenue. Does anyone know if this person was
You know
here?
what?
You don't have to speak if
No,
you're
no,
here.
no. You know what it was, Mr. D'Amato? I think I can answer the question. Yes, there was a young lady who was sitting in the front row when the board came out, and I was introduced to her that she was interested. She had received one of the notices. She said she lived on the block. She wanted to know what was going on. She thought she had to be here because she received the notice. And
We get that.
Exactly. And I explained to her that my client was looking to build 3 homes. She says, that's fantastic. I thought there was something going on with business. And I said, no, absolutely, this is not a business thing. These are residential properties. She says, that'd be great. It'd be great for the block. And obviously you're taking my word for what she said to me. But that's, after we spoke outside, she said, I'm fine with everything, and she left. So I'm certain
Okay.
that was the woman.
Okay, is there anything else you wish to add?
Yeah,
then,
if
Mr.
I just may segue into it, and I just had a couple of minutes. I apologize. Somewhere in here, I did talk about the owner occupied. Everybody, I think, talked about the eyesore. It's been like that for a number of years. Ms. Bianco said at least 5 years. And, and the last thing I added, I know it's not zoning, but it is an impact on the community. The people in Roosevelt are stuck with the fact that there's very little commercial property. I know Mr. Boyd is doing a heck of a job building up the Chamber of Commerce, but as far as the tax base goes, the lack of commercial property, let's say they don't have Roosevelt Field, they don't have any of the big shopping malls or office plazas or whatever over there. So anytime you can add something as far as the houses go, whatever, there's
Increase the
another part
tax
of the
base.
tax base in it. Again, I know that's not zoning, I'm not pretending to make that
No, but it
argument,
matters to
but
the
there is
community.
there is an advantage because every dollar helps, particularly the school district for the people of Roosevelt. And that's my case.
One last thing, Ms. Perry mentioned that there might be others who wish to speak. If you are here, wish to speak, but just haven't signed in, you still can speak. We cover, did you want to speak? Okay. So what I'll have you do is come up here, get sworn in, give your name and address for the record, and before you leave, I need you to sign in, so you get a copy of the decision also.
My name is Jacqueline Ellie.
Lower the mic.
My name is Jacqueline Ellie Shahan. I live in Roosevelt, 235 East Pennywood Avenue in Roosevelt. I'm a resident, homeowner, and independent contractor that lives in the town of Roosevelt, and I feel that this would actually bring out better values to the homes in the neighborhood of Roosevelt.
Okay, thank you.
Thank you.
Okay, with that said, Mr. O'Brien, you're finished?
We're finished.
Okay.
First of all, I thank the board. I thank everybody who took the time, not only to come out, but most of them were here all morning, so.
Yes.
Very appreciative
Our
by my
apologies.
client.
Okay,
We're
then
done.
if there are no,
I have a question.
Yes, sir.
go ahead.
Mr. O'Brien, hi, how are you? One of the gentlemen said that the fire hydrants in front of the property, that's an eyesore to the community for the last 5 years. Whoever, the development company that owns it, why aren't they taking care of the street? Like, aren't they supposed to cut the lawn and keep debris away from the fire
Well, you say
hydrant?
the street, my client has fenced in the property. So
Yeah.
the fenced in does a couple things. It keeps the place from being vandalized, being set on fire, having squatters, doing whatever they can. So
Aren't they responsible for the street curb, the grass or
yeah,
whatever's there?
Maybe Mr. Bianco can, I
Because
know where you're going.
My point is, I don't care what happened in the past, but can you just, if there's a problem with the fire hydrant being overgrown, can you fix that, you know, in the interim?
James Bianco, New York Land Development. That property's been a dumping ground for many, many years. We fence it off, and unfortunately, they find a way to still get in there. We did have a landscaper throughout the entire year maintaining the sidewalk where the fire hydrant was. Should the board approve this, then we're going to demolish the house and get it all cleaned up.
And in,
Absolutely, we have all year. Yes.
Oh, yeah.
When the gentleman said that,
Yeah, we have maintained the sidewalk throughout our ownership.
You know, I've had the pleasure of representing Mr. Bianco for a number of years, and he appears to take very good care of his properties. But let me add something. I'm in total agreement that a fire hydrant must be maintained, must be protected, not only for the benefit of this property, but for everybody in the neighborhood. So we will, I promise the board
give us your
that
word
there will
that
be
you'll do it.
special attention
Thank you.
provided to that.
because the gentleman just happened to call it to our attention. That's
all right, and that'd be from now on, not just once we approve it, or if we
The
approve.
worst thing that could happen is because of some sort of negligent or affirmative act on your behalf, somebody gets hurt or somebody loses their home. That would be horrible. And I'm in total agreement with that.
Terrific. So there being no further questions from the board, do I have a motion?
I move the hearing be closed, the case placed on the decision calendar. When the board renders its decision, all those who signed in will receive a copy of the notice.
Okay, thank you all for
Second.
coming and participating. Have a safe home, everyone. Second, all in favor?
Aye.
Next, we have case 68024, Levittown, Mary Ellen Thielsen. Variances, front yard average setback, side yards aggregate, maintain addition, maintain enclosed breezeway addition, and partial garage conversion to living space, all attached to dwelling, also known as 19 Green Lane.
I'm sorry, Patrick, did you already call it? I take it?
Okay,
Have you been sworn in, sir?
yes.
Shh, okay.
Robert Rowena, 20 Sylvia Drive, West Jessup, New York. I am the architect on 19 Green Lane in Levittown. The homeowner hired me to do a dormer on their typical Levitt house. And during this process...
Folks, can we keep it down, because we'd like to be able to understand what the gentleman is saying. Okay, so if you want to have an extended conversation, please do it outside. Thank you. Go right ahead, sir.
So in the process of doing this dormer, some work that was done without a permit came to light. This work was done by the previous owner, and the current homeowner was unaware that it was not CO'd.
Is that the breezeway and the partial conversion of the garage to living space?
Yes. So the house was built in 1948. The garage and breezeway was built in 1963. And the homeowner came into possession of the house, I believe through inheritance in 2017. So sometime between when the garage was built and when they came into possession of the house, this work was done.
How'd your client come to know it needed to be legalized?
An inspector came for the new work that she was doing to the house.
Okay.
And this came up during inspection.
All right, what's the front
What are
yard?
the numbers?
Average setback you request, side yard, aggregate, what are you supposed to have?
So there were 2 bay windows, which were actually a part of the garage and breezeway work that was done in 1963. And the front yard setback is 22.8 to that work, which again was done previously.
What's it supposed to be?
I don't.
Hold on. Looks like on your chart, it says it's supposed to be 33.05.
Yes. Yes.
Okay, and
The average was 33.
although, hold on. This says that the average is 33.05, that the existing is 25.7, and that the proposed is 25.7.
Yes, so the 22.8 that I just mentioned is to that bay window from the survey, but the main house itself is according to that drawing, and then the work that was done above it, it was a dormer, followed that setback.
That's not permitted, is it? I need to use the 22 then, right? The chart's wrong. Right. Right, but he's got 2 existings. So, look, he says the bay window here is 22 something. No. Permitted? So then, look, Vicki, so that's my question. Because look, the sheet says he needs 25. I don't want to grant 20, but he thinks he needs 22.8 because of the front window. But he also has to do the breezeway.
The breezeway was already under number 4.
He thinks it wasn't.
I know that. I corrected it in the on the planning.
Hold on, wait, look. Here's our calendar. Maintain enclosed breezeway addition and partial garage conversion.
Because that was the portion of the breezeway that he extended out.
So he is, I just want to know, does he need all these 3 things?
Yes.
Okay.
For the garage.
Right, but I'm still waiting, Joe.
Front
On the
yard is
front
for
yard.
this little section right there.
So he does need it at 22? That's my question. Because his chart says 25.7. So 22.8 is the right number. Okay, so according to our plans examiner, who's an expert of all experts, you do need the relief for the 22.8. Your chart says 25.7, so that's why I wanted to check it.
Yes, sorry, I believe the confusion was that plot plan was originally done for the dormer work that we were doing, and the setback to the new work
I
was
see.
25. But now
So-
on this variance, taking it to the bay window, the
All
bay
right,
window
hold
is
on.
22.
So let's just have that. You're the architect?
Yes.
Here, can we, Dawn, can we have him change this 25, have him change the front yard average setback number and initial? No.
Okay.
Where he has proposed 25, he needs to change that to the 22.8, or whatever it is. Say 22 and change.
How do you know whether or not the foundation is solid? Right.
Because that's the one that, because if we leave it, yeah. Because if we leave it 25, he's gonna run into a hiccup.
Okay.
Yeah, if we leave it 25 on that and then they do the inspection with that, then we run the risk of them not realizing you can encroach to 22. All right. Okay, I think we mostly understand what happened here and what your needs are. Is there anything else you wish to add? You gave us the side and side yard aggregate for the record?
Yes, it should be on that chart.
Why don't you just put it on the transcript?
Sorry, I don't have that sheet in front of me.
Okay, looking at your diagram, just to make sure when I read it off that you agree that's the request. Side yard aggregate required 15, you're proposing 12.8. Regular side yard is required 5. It says you have 5. I know.
I believe the aggregate is the,
Oh, you're right, I apologize. I had noted side yard aggregate, side yard also. Okay, good. So those numbers, that's, you believe that the number I gave you for the side yard aggregate is correct, given what you're looking at, right?
yes,
Okay. Are there any other, is that your case?
yes.
Are there any other questions from the board? If not, is there a motion?
The hearing be closed, the case placed on the decision calendar. When the board renders its decision, you'll be notified.
Second.
All in favor? Aye. No, I didn't realize John was sick.
Thank you.
I got the last call since she just,
I didn't realize.
the body was not even cold before. Body's not even cold.
The only thing is, she does a good job with that.
That was funny. I turned around and John's sitting there like,
All
oh my
right,
God.
that concludes the morning calendar. No?
we have a second call?
We do have a second call. Case 68 of 2025, Edward Kalmus, renewal of agreement. Okay, so it's a residential case, even though there's no one here. I think it's appropriate to grant an appearance waiver. And that being said, the building department inspected the premises on October 31st, 2024, and found that all conditions previously imposed by the board have been and continue to be complied with. Are there any other questions from the board? If not, do I have a motion?
Move the hearing be closed, the matter be placed on the decision calendar. The applicant will be notified by mail of the board's decision once it's rendered.
Second?
Second.
All in favor?
Aye.
Any opposed? Any abstentions? Okay. That concludes the morning calendar. We'll take a short break, and then we'll do some decisions. And Patrick, you correct me if I'm wrong. Well, we have one case on this afternoon. That's it. It's going to be adjourned. So we'll do our decisions now, work right through, and then hopefully we'll adjourn shortly after 2 p.m., and then everybody will meet at the disco, a part-time disco.
Oh, wait, is that?
Can we start decisions? All right. Case 68 of 2025, Oceanside, Edward Calmus, renewal of a grant to maintain a 6-foot-high stockade fence. We granted an appearance waiver on that case. Second call. Do I have any comments from any of the board members? Any questions or a motion?
I have a
Take-
motion,
take your pick.
index number 6825, Oceanside Calmus, renewal of a grant to maintain 6-foot-high fence be granted with conditions 5 years.
I second it.
All in favor?
Aye.
I have one question, one comment. Can you ditch the index number routine? They're case numbers. Okay?
A case number and an index number is the same thing.
No, they're not.
Yes, it is.
Case numbers are
Let's
different.
check the CPLR.
All right, case number 69 of 2025, Belmore Andrew Smart. That's also renewal of a grant. Do I have any comments? That's affecting premises 2053 Russell Street in Belmore. Any comments from the board? If not, do I have another motion?
I make a motion to move case 6925, Belmore, Andrew Smart, renewal of grant to maintain pool with surrounding wood deck.
Same conditions?
The same conditions.
Temporary.
Conditions.
Second, all in favor? Any opposed, any abstention? Case 70 of 2025, Levittown. Wayne and Carol Wickern. That's a renewal of a grant to maintain a fence. Any property address is 124 Haven Lane. Oh, that's adjourned to 26th at 11 a.m. All right? Case 71 of 2025, Levittown, Orlando, and Ida Valencia. A renewal of a grant to maintain another 6-foot-high fence forward of the dwelling. Property address 35 Norman Lane in Levittown. Do I have any comments? If not, do I have a motion?
I move case 71 of 25 in Levittown, Orlando, and Ida Valencia, located at 35 Norman Lane, be approved as requested, temporary, same
Second.
conditions.
Second.
All in favor?
Aye.
Opposed? Case 72, 2025, Merrick, Arthur Tassiello. We granted an appearance waiver on that case. Also, renewal of a grant to maintain a 6-foot-high PVC fence and principal front yard and clear sight triangle at the applicant's driveway, and a 4-foot picket fence with clear sight triangle on State and Frederick Avenue. Property address is 1899 State Street. Do I have any comments? If not, do I have a motion?
Mr. Chairman, I move that case 72 of 2025, as you previously described it, at 1899 State Street in Merrick be approved as requested.
Second.
Same
Same.
period of time and same conditions.
Second.
Second.
All in favor?
Aye.
Any opposed? Any abstentions? Case 73 of 2025, Merrick, Ionas Babatsikos. That's a renewal of a grant to maintain a 2-family dwelling with 2-car detached garage at 1880 Meadowbrook Road in Merrick. Any questions? If not, do I have a motion?
I move case 73 of 2025, location of property 1880 Meadowbrook Road in Merrick be granted as requested with all conditions.
Second.
Second.
All in favor? Opposed? Case 74 of 2025, Merrick, Barry Wallfish. Katura got a kick out of that name. In any event,
I'd rather be a wall fly.
we have
But
no
maybe the
secrets
fish
here,
attacks the
Mrs.
flies.
D'Amato. Variances, lot area, front width on street line to front yard setback, front setback line, lot area occupied, side yard aggregate, maintain a dwelling with a shed addition. I believe we have some discussion on that.
We do.
Okay?
The existing side yard with that shed attached is 3 feet. Without the shed, it's 5 feet, 5.5 feet, actually. The shed has to go through extensive work in order to be legalized, and it's, my opinion, it should be removed and relocated somewhere else. So that,
as to what?
so as to maintain the 5-foot side yard.
Because?
I think it's critically important that we maintain the required distances for side yards for fire spread, based upon what's been happening in California and locally. There's a reason for the 5-yard setbacks, and
5 foot.
this is not necessary, it's only a shed. So that would be my,
Would you like to make a motion,
well,
Mr.
does
Pellegrini?
anybody else want to contribute anything, or?
I agree.
What did it house? Did he mention what it housed?
It's just a shed. She said storage.
Oh.
But they've incorporated into the siding, so it is gonna be a little expensive.
No, I disagree with that. A siding is pretty inexpensive. and
Peanuts.
Well,
It's an easy,
I wouldn't imagine you would try to get, I think it'd be a nightmare to try and buy match siding. But I imagine you could save what you take off, and that's
you
probably.
could do that. Yes, that's a good point. I don't think it's a self-created hardship, and they gotta get out of it.
Like
So,
that one.
What's your motion?
If there's no further discussion, I would move that this case, 74 of 2025, Barry Wolfish, for the variances lot area from and on the street line, front yard setback, lot area occupied, side yards aggregate, maintain the dwelling without the shed, that the shed be
Granted in part, denied.
You deny the side yard.
denied the side yard for the shed, yes. Maintain a 5.5-foot side yard as
Can we just
proposed.
confirm that the side yard is only for the shed?
Yes,
It is.
yes, it is only for the shed.
In either case, your motion is to only deny this portion of the side yard request that relates to the shed.
And maintain a 5.5-foot side yard setback.
Well, we can't say five
Side
and a
yard
half.
aggregate.
Well, that's what it says
Side
here.
yard, yeah.
So basically, to grant the lot area fronted from and on the street line,
I know, but
to and
they
from
can
the
have
setback
Okay,
line,
5
lot area occupied,
You know.
and maintain dwelling, but deny the portions for side yards aggregate, and to the shed.
To the
Well,
extent they
wait,
apply
wait,
to the
wait,
shed.
wait.
Right.
Yeah, to the
That-
ex- okay.
If I'm not mistaken, I believe that this house never got a C of O,
Right.
so they need to maintain the dwelling as part of this
Right, right,
application,
right.
regardless of the shed.
So that's why we gotta be careful about
Yeah.
that. We got it.
Thank you.
This is
I
the one.
second.
This is the one that's still, you know, that they still have yet to close out the
Yes.
dormers. And did we ever resolve the issue with regard to the balance of the home? Because the rear portion of the home with the separate entrance,
No.
that, you know, how do we know whether or not that was ever legalized?
Well, I assume they would have found it when they inspected on this.
Building department?
The building department, they denied it down here for the relief that's in front of us.
Okay.
So assumedly, they would have denied the rear extension if it was
Okay.
not part of the application.
Can we, in our decision, recommend that the building department do a final inspection of the entire house?
They do.
They do
a
that.
final inspection.
They do that ordinarily, don't
Do
they?
they?
They do.
I believe they do. I was told that
Especially since
on
our grant is to
a
maintain a
number
dwelling.
of occasions.
Okay.
All right? We have a second on that motion.
He did.
All in favor?
Aye.
Any opposed? Case 75 of 2025,
'Cause they went out.
North Belmore. Donna Sarfati, that's the mother-daughter residence at 2185 Rosemont Street. Any discussion? If not, do I have a motion?
I make a motion on case number
Thank you.
7525, Belmore, Donna Sarfata, mother-daughter residence, second kitchen, be granted with mother-daughter conditions, 3 years, subject to verification.
Second?
Second.
All in favor?
Aye.
Opposed? Next case, 76 of 2025, has been adjourned to March 19th at 11 a.m. Okay, case 77 of 2025, Levittown Satwinder Bayana. There was a cropping issue, so we're going to hold that case pending signed and sealed plot plan, correct?
Yes.
Okay,
Patrick, you'll check with the break.
Mr. Chairman, does holding like regular past until next time?
does what? What?
Well, only if he comes in with
If he
it,
comes in with it,
we'll incorporate it, close it, and leave it.
Doesn't appear on next week's calendar.
Unless he doesn't come in time, then we're gonna have to put
next
it
week
on
we
the
don't have a
reserve.
meeting.
It's only open so that we can accept the document.
Yeah.
Oh,
Yeah.
oh, I see.
Oh, You
Yeah,
wanted
that's pretty much
you
what I
wanted a
mean.
clarification on the word hold? Okay, most people know what hold means. However, there are exceptions. All right, case 78 of 2025, Baldwin, Jackie Covington, variances front yard setback on Centennial, rear yard, construct a one-story addition attaching dwelling to detached garage and convert a portion of the existing garage to living space. Do I have any discussion with respect to this case? If not, do I have a motion?
Yeah, I make a motion for case 7825 Baldwin, Jackie Coverton, variance front yard setback on Stellino Avenue, as requested.
Second,
Second.
all in favor?
Aye.
And Mr. Plumer, you see how easy it is to refer to it as a case? Even Mr. DeGrace picked up on that one. Okay. Case
What are we doing? We said okay.
79 of 2025 in Woodmere, Mark and Sarah Schmerler. Okay,
This is the case where they are in the process of obtaining a state variance for.
No, they haven't.
they had it, they had it, yeah.
I'll give it to you. I wanted to read the rationale.
Oh, okay, sure. I have you on.
Yeah.
Okay. 79 of 2025.
Am I up to bat?
Got to pay attention.
Okay.
Oh, Kim's up to that.
Let her do it.
No,
Go on.
You do.
Oh, okay, no, she just wanted to read it.
No.
So,
Is she reading it?
No, I mean, I want to read it myself.
Oh, okay, fine.
Great.
We need another clarification.
Okay. I move case 79 of 25, Woodmere, Mark and Sarah Schmerler, located at 942 Carroll Avenue, be approved as requested with conditions.
Second.
All in favor?
Aye.
What are the conditions?
the conditions are gonna be to comply with the state variance, and there's also gonna be an explanation as to the DFE and the BFE, and that there is compliance with the BFE, but not the DFE.
Yeah, those conditions.
Yes.
Okay. Case, I was absent for case 80 of 2025. I had a step in the back. Baldwin, Adeline LaRose, special exception to maintain a second accessory structure, which was a shed, higher than permitted and exceeding horizontal maximum at 1016 Thomas Avenue in Baldwin. Any comments from the board? If not, do I have a motion?
It was, 9.6 on that and 12.3 on one of the horizontals. I move as it relates to case 80 of 2025. As you've described it, it's Adeline LaRose. The property is 1016 Thomas Avenue, that the application be approved as requested.
Second. All in favor?
Aye.
Opposed and abstention. Case 81 of 2025, Baldwin, 1725 Conway Street, LLC. Variance front yard average setback, complete construction of a dwelling. We're going to hold that case. Pending
Yeah, further review.
further review.
They're supposed to get periodic inspections with the building department,
Yeah.
and they're supposed to be confirming on site to make sure you don't run into an issue with. I don't know. I don't
Well, they didn't inspect the foundation, so why would you?
Correct.
That's my point. I'm a little worried about it.
Sure.
It looks pretty tall.
Sure.
Well, with all due respect, Mr. Plumer, to people your height and my height, everything looks pretty tall.
I'm taller than you are, Chairman.
Not by much. That's because you wear lifts. Case 84 of 2025, Aaron and Mitchell Gorin. Variances height, lot area occupied, side yard aggregate, construct a dwelling and demolish the existing at 114 Oak Street in Woodmere. Any comment?
Oh.
Any discussion?
Well, my thought on that case was that it is a huge house. I know they need a huge house. But the first floor ceiling is 9 feet 6 inches. If we were to deny the 18-inch request, then their solution would be the same exact house with an 8-foot ceiling in that area. And I don't think that's much of a hardship, but I'm open to hearing what others have to say.
My
first floor height? I didn't
9.8.
9.6. Oh, exactly the 18 inches.
Yeah, but in these big houses, they don't want an 8-foot ceiling on the first floor. You know, I think they'd be more apt to taking the attic and make it, because it's supposed to be a storage area.
I will say, on the flip side, I was surprised, and I do find it compelling, that they provided us with that ridge height of all the surrounding houses. On that block alone, there's a house, two houses, the house right next to them exceeds the height request they have. The next house is,
130 Oak Street, that we had a picture of.
no, but that doesn't exceed.
That's the brick
So,
house.
hold on. So the house directly to, if you're facing the house directly to the left of the subject property, it's only 54 and change, so it's about a foot lower than their proposal. I'm sorry, it's above theirs. The next house, the one he's talking about, is at a foot lower. The next one is higher than they request. And there are probably in that 200-foot radius, just at least 10 or 15 houses with a height higher than they're asking for, which surprised me.
One thing that you got to know about the neighborhood is that that's between Central Avenue and Railroad Avenue, which is basically the Far Rockaway line of the railroad. So you have all these side streets there, and it really doesn't affect anybody. It's sort of harmless, and they're a lot of them are big old houses with a lot of bedrooms and a lot of facades. So, I don't see any, I understand, we sort of have a problem with height limits, so that's the only issue. Everything else is sort of fits the neighborhood.
I think we might be able to overcome the negative precedential value it might have by articulating if we were to grant it, by articulating in any such grant the significance of so many of the houses surrounding it having a height higher than this house. So I can go either way. Christina, did you?
She always says that.
I have,
She can go either way.
Christina, did you see that ridge?
I have a real problem with the attic. The attic is 6'7". They can make bedrooms up there.
Yeah, they should lower it.
What?
They should lower it so that they can have the grand.
And then they can keep the
ceiling,
height on the other floor.
You know, in the first
They can
level.
keep the height of the first floor, lower it to 5'1", and then.
Well, what do we deny to
that's
make
fine
them
for
lower the
storage.
attic?
Right.
No, but they'll likely,
Yes.
what if they redesign by taking out the first floor? Can we be more specific? No, because she specifically wants to preclude the attic. I'm just trying to figure out,
Yes.
oh yeah, you can.
Sure.
But the question is, we don't have to argue. Trust me, you can. But wait, what do we deny to specifically do what you asked? Because, hold on, because they don't have a third story. And if we deny the height, it's 18 inches over, they may very well just make the first floor 8 feet ceilings. I don't care either way, but if the target is specifically the attic, I don't know that we're guaranteed to get there this way. If that's okay with people, it's fine with me.
So let's say granted it the way it is, but we had a provision that there could be no bedrooms, it has to be storage space on the third floor, would that be okay with you?
And he did say it's a pull-down staircase.
Just.
Well, how are we gonna,
Well, how are we gonna enforce it, no matter what we do, after we do it, they can just do it anyway.
I would say,
Well-
if the board is not inclined to grant the height variance, you can either straight up deny it, they redesign the house, or you can deny it, and you can have the provision that the applicant is to reduce the height of the attic by 18 feet to come into compliance with.
18 feet.
I'm sorry, 18 inches.
Or we could grant the height variance on the condition that, or you're right, we would deny the height variance with the condition that,
They reduce the attic by 18 inches.
I think that's good.
They have to change the pitch. Their option. Or else, correct, if you just deny
I'm
it,
not
they
sure
can
if we,
redesign it.
What would, if we denied this, would it be an easy Article 78 if there's all these other houses around?
They're non-conforming. What you have to be.
I'm just asking.
No, understood. The issue that you have to be concerned of is precedential value.
Correct.
Yep.
So you see granting of a height variance, but then you have somebody who accidentally builds a house too tall, let's say it's
Yeah.
Now you got
13
precedent.
inches less than this.
Yeah.
that's why I said if we were going to grant it, we would have to have an explanation about the significant, compelling evidence of all those, because I was surprised. There's 60s, and a lot of them, 60, 62, 58, 59. So I can go either way.
But I think Monica already said that they're old houses. A lot of the old houses, it doesn't matter.
Well, the testimony was that some of them were older. And when we say older, I don't mean non-conforming, like before 1930. They didn't look like that.
They could have before you had the height.
The house will remain the same size, just
And it's got a huge
reduce the
basement
roof,
too,
18
they
inches.
said.
Yes.
The basement's
Or whatever they
huge.
want.
So I say we do the attic lower.
I'm just
Because
trying to
if they have
figure
a
out
huge
how we,
basement-
I'm just trying to figure out how we compel that.
So it's either make them reduce it to the 30 feet or don't, you know, so.
No, but,
So we do both, there's no other way to do it.
no, but she wants it to be the attic in
No,
specific.
I didn't say I wanted it to be the attic. I said I wanted it down, and if you want to give it specific, let's do
Yeah,
the
'cause
attic.
the only way to
You
get,
were
the
talking
only way
about
to
the
get it
first
down, you
floor.
can't tell them what to do, you just say, listen, the height
Well, you can't.
requirement is 30, and you gotta somehow figure it out.
Yeah,
It should
You
be
know,
up to
that's
them.
what we want
let
to
them
do.
redesign what they want.
That was, see, my personal opinion is, I would grant it because of the neighborhood, but that's my opinion, there's nothing etched in stone. But if you drove down that street and looked at the houses, it wouldn't matter, it wouldn't
I
matter.
found that, Rich,
In my opinion, but everybody's got an
diagram
opinion.
compelling.
Are they new houses?
But
Well,
No.
the character is the character.
I know
They're all
big-
old.
They're all big
Oh,
houses.
big old homes.
They
All
all-
of them in Rockville Center or way above?
It's like when I went to Buffalo Street, like
is
that
in that?
case from last week when the chairman sent me there in East Atlantic Beach. So you had these old bungalows, and then you had these big three-story houses with balconies, but that's just the way it was. But we were granting the three-story houses, you know? Like, so things change, I guess, you know? I don't know.
Well, this is the new,
Can somebody, would somebody, yeah, somebody should make a motion.
The house? It had that, what is it called, a mansard roof that goes, that is, not flat, but yeah, kind of flat.
don't they?
And then it has these long
Yeah.
pieces, and then it had some windows.
I love those because the roofs,
They do whatever they want after we're finished anyway. You gotta see how many cars are in the driveway.
I'm sure.
And they have a lot of relatives or kids.
Maybe that's why we
When I say they, you know, religious.
Well, I'm not sure if I'm using the term.
Yeah, the Yamaha, and plus that whole area.
Yeah, is it the one that goes like this, and then it kind of goes like that?
Do you want to just deny that?
I would go either way. My vote would be to just grant. That's my vote.
somebody make a
I mean, I
motion.
think they have a good case.
Somebody like to make a motion?
Make a motion, Joe?
Can't
No,
make
I
a
don't feel
motion.
strongly, so I
don't have a problem.
I don't particularly either, because only because of that compelling evidence on that. But so I don't
yeah,
feel,
but this is a new house.
Yes.
So I kind of feel like if you're gonna now
But it's
do a
character of the
new
neighborhood,
house,
too.
then the next person that's gonna do a new house is gonna say, hey, they got this in the
Yes.
attic, so I want this in the attic.
but it's also supposed to be the
So
character
I'm
of the neighborhood.
against. I say,
What about you, Chairman? What's your vote?
I don't have a vote,
You guys?
You do vote.
only in the event.
I don't feel strongly enough to make, I think whoever feels strongly,
I didn't listen to that case.
You didn't? Well, so you're out.
I was in the
So you
back.
don't vote, though. You were correct.
For Woodmere, this one?
yeah, he's right, I chaired it.
Oh, okay, so.
So Kim, you want to make a motion just to deny the house?
Somebody should make
Go
a
ahead,
motion.
Oh, I'll make a motion to deny the height. Can we put it back in the attic or no?
Let them redesign the home.
See, I
Give
kinda
them options.
I feel like the condition goes with the grant, that's my point. We're denying it, but you have to reduce the attic, right? The condition would go,
I would say if you, look, this is my own opinion, I don't have a vote on this case, however, my opinion is deny the height and then let them have the option as to.
right, I think you have to if you deny. It's weird to say, we're denying that, but we're making you do this, that's related to it.
No, but don't you remember the house down there that we denied, we really didn't deny, well, I guess we denied the attic, and then they came and had all the windows in the bedrooms in the attic?
They came
they already have the windows up. Yeah,
So maybe we be specific then, so that they can't do bedrooms in the attic.
Somebody want to make a
And
motion?
if that happens, they're gonna
We
spice
also
it.
say that there cannot be bedrooms in the attic.
Sure.
it already has that condition.
Yeah, that it can't be converted to living space. This would be constructed line, so it would come with the, I do look at every file when I'm doing the decisions, and I would specify that no sleeping, no cooking in the basement, and no conversion to living space in the attic.
And you
I do
can
specify that, and
condition,
garage.
well, again, we can't always police it, but he said on the record that the stairway is only a pull down, so you can
We can-
put a condition that it must always remain that way. The question I had was, as a legal matter, I'm not seeing a clear path to denying something and putting in a condition. Usually a condition is, we're gonna give you this, provided you do this.
But, see, I don't necessarily see an issue with specifying that, you can
Well,
have
those other conditions that don't relate.
But that you can have your 8-foot ceiling. The board has a concern, which is, I think, common in certain areas, that there are third stories that get added. So this would, I think,
You could, with the rest of the grant, you could say, but the length must be always maintained, la, 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 as provided in the testimony.
this would
and is-
ameliorate the board's concern. If the concern is that the attic, since it is 6 foot 7.5 inches in height, if that could be converted to living space, it also does have that flat roof, so it's not like just the peak is,
So what would you say? You deny the height, but say,
if that's what the board is inclined to do,
no, but I'm trying to follow the rationale.
I think that if the height is denied, I do think to meet the board's concerns that the attic could be converted to living space, I don't see a problem that you are required to reduce the ceiling height by 18 inches to come into compliance. But I also I also think that it's, let the applicant do it. So, but I don't see an issue with that, is my point.
So what about conveying that to the applicant's attorney prior
Sure.
to our making the decision?
Sure.
And then let them come back to
Oh, sure.
us?
I think
and
that's
say,
I'll contact Mr.
Yeah,
Bonesso.
because
He's
that-
very
it's
receptive.
weird to say we're denying your request, but need a sequel. All right, well, I would just say that, yeah, I was gonna, that's what I was just gonna say.
Never said anything about 3 houses. They said, oh, we want it cleaned up.
Well,
So do they really know the difference between 42 and everyone else has 50 or more?
Well, Joe, number one, we gave them copies of the materials to review, and they were very, very astute at doing so. Joe specifically asked in front of everyone, to one of them, do you realize they could build 2 houses as of right? And the person still said, absolutely, but we want these houses.
It sounds like the economic variable is very important.
I agree.
And I think that, having a third house.
No, not that one.
Helps the tax base. And they indicated that they have very, very little commercial base, tax base in Roseville.
Agreed.
So, to me, the 3 makes sense, and everybody in the community was on board.
Yeah,
with it.
that's what I was gonna say.
So I believe it's a good project.
I
think
do
everyone in
too.
the community was not on board with 3. I think everyone in the community was on board, we're going to get this place cleaned up.
Yes.
What bothered me about, what bothered me is there was only 3 people that came, and they were basically for it. So the person that's the head of the Commerce Department or the Chamber, what does he do for a living? Is
John
he a real
Boyd.
estate broker? No, I'm just, we didn't
But
have
the
like.
people who spoke were very, that one gentleman, Mr. Burrell,
Yeah,
he
but
was
why
very
was,
articulate too.
there was only 3 people, and they were all for it, which I found
were
odd
fine.
for, but, there wasn't any community opposition, which was good.
Agreed.
Which grants it, but it's whether, it's just like the height on the building we're talking about in Woodmere. Do you want to set a precedent where you could, if you look at the lots next door, there's a lot of 10 feet there, 20 feet, you combine it with the 40, and then all of a sudden you have, 3 more houses. So it's whether you want to set a precedent of giving them 4,000 square foot lots as opposed to 6,000 square
But
foot.
almost the entire neighborhood was 50 by 100, and if you surveyed what was there, there were very few. There was one house that was on an 80, I believe, on the back street, that, yes, if you tore down the house, you could put 2 40s, but there were very few other lots in the 200-foot radius that lent itself to creating 40s because there were so many 50s.
Yeah, but that's the whole thing, they were all 50s.
Right.
Right.
And right beside it is 60, 60, 60.
And then there's a 10 and a 20 that you could add to the 50, or there's a 10 and 20 foot lot on the left of it. You can combine with a 50 and get 2 lots,
Yeah.
But I don't think it's that much of a deviation from the neighborhood. I don't think there's much risk of it having precedential value negatively, because in that area right there, and I agree with Mr. DeGrace that it was all the community wanted it to clean it up, to make it look nicer, and the tax base issue was an important one.
See, I see another thing, and I agree with Toro. I think that if we don't grant it, it's going to take a very long time for another builder to come in and say he'll build 2 houses on that property. Because it's not cost effective.
Agreed.
That's my opinion, and then it's going to stay the way it looks. It looks horrible for who knows how long. It could be years.
And the fact that they're gonna be
So I think we have
owner-occupied.
to expedite this.
I agree, and I think the fact that, as always, they agree to owner-occupied. So, like the one woman testified, we need more people in here who own their homes.
And also, what was a positive was the community said that the builder had built a project around the block.
That's right.
And that they were happy with it, which.
Yeah, they have an
which,
experience
you
with the
know, an
builder, and they
experienced
were,
guy, yeah.
and it was a positive one, and they wanted more of it.
Don't you think that this is gonna create a precedent for 41s? 341s?
Where, in that neighborhood?
In that neighborhood.
Because that neighborhood doesn't lend itself to that.
How many other lots are there? I remember we denied them in Roosevelt.
No,
I'm
the
not-
other,
Yeah, but
I'm
at
not
other
there.
times,
there are
Position.
little, if no other lots that would come in for 40 by 100.
We had one that we did in Roosevelt where they could have put in 15 other ones. Anyway.
well,
this
the
one,
whole thing
no.
is about Roosevelt, okay? every time these guys come in, they'll say, oh, over there, you did this. It's
Well, they
not
do that in
always
every
within the-
community.
It's not always within the 100 or 200 foot
Roosevelt apparently is only, what, 1 mile radius? Yeah, 1
But
square
this,
foot.
in this.
So I think they
John,
can always come in and
the
say,
answer to
you
your
did this
question,
in Roosevelt, so
in the
now I
whole
want
map,
this in Roosevelt.
almost every place
So the option
was
would be
50
what?
by 100.
Either 341s
There
or
was
260s?
literally-
Yeah,
or
60s as of right.
Literally, almost no place where this would have
So
a negative.
you're in
residential
favor of 2
impact,
houses?
Because all of them were already,
I mean,
there
I
was
was
no one
looking on the
sitting
plot
there.
plan. I
There
didn't
was
see
one
any of the
house on
40s.
an
I saw
80
50s and
that,
60s.
okay,
All
they could rip it
50s
down
and
and make
60s,
240s.
and 275s on the other one.
Yeah.
Go from 41 to
So,
35.
I mean,
You know what, if you
260s
look
works.
at President Trump the other day with the disaster in California, what was he talking about? Let's move this.
Yep.
Let's not procrastinate.
And the whole place is
Let's
in
do
favor of it.
You know, I believe that's important.
Yeah,
Because it's gonna just stay the way it is. It looks stupid to me.
Agreed. And the people are all in favor of it. Why would we like, and again, the precedential thing, there was one house that I saw that was an 80, and if they wanted to tear it down and get 240s, that could come before us. But all the houses were on 50 by 100.
Which is a conforming lot.
No, 55 is. But I'm just
Those are
saying.
old houses, they're old.
But I'm just
Work.
referring to the precedential issue, in terms of who might use this on those streets in the future. There's no one who has I remember one house, but most of the houses don't have something they're gonna ask to divide into 40s.
Well, they can take 260s and make 3 houses.
Oh, you want me to chair?
I'm
Recused.
All right, well, I was actually gonna make the motion on this. But we have a sequel we need also. Okay, so I will, you're the chairman, so you can share even though you're, I think you can share even though you're not voting. I don't know. Anyways, as it relates to cases 85, 86, and 87 of 2025 in Roosevelt, which are the proposed subdivisions of a lot by New York Land Development to Corp., affecting the property at 123 Frederick Avenue, again in Roosevelt. I make a motion that based on the testimony at the hearing, the documents in the file, and other reviews done by members of the board and otherwise staff with the building department and the zoning office, that we adopt a negative declaration as to the CEQA determination.
Aye.
I further make a motion as to the same 3 cases that we grant the requested relief to subdivide it into 3 lots and construct 3 homes, demolishing the existing home on the 1 lot, with the condition that they obviously meet all new homes conditions, including, if it's not already included, no cellar entrance to the basement, no cellar entrance exterior, and that each dwelling be owner occupied on, covenants that are filed to run with the land.
Second.
All in favor?
Aye.
No.
Okay,
Okay, so,
4-2.
A,
Local, so we're okay.
okay.
Next, case 680, 2024, Levittown. Mary Ellen Fields. Variances, front yard average setback, side yard aggregate, maintain addition.
And you guys feel strongly
Maintain
more?
enclosed breezeway, addition, and partial garage conversion to living space, all attached to dwelling. Property address.
I move that case 680, 2024, Mary Ellen, Thucian? Theolison, okay, at 19 Green Lane in Levittown be granted as requested.
Second. All in favor? Aye. Opposed?
Okay.
It is now 1:09.
So
We don't get any lunch.
the
You
Roosevelt
guys want
case
to do
is
reserve,
4-2.
or you want to do that after? I don't,
I'll do it one more.
The
Whatever you
Roosevelt
guys
case
wanna
is
do.
We don't
4-2.
get any lunch, right?
What time is it now?
Kim chickened out, she didn't like it.
All right, let's,
Okay.
and let's do reserve.
Okay, reserve.
We're gonna have dinner at 5:30.
Is it 5:30?
You didn't get the memo?
Well, you could be there at 6:30.
How about we do calendar?
What?
Maybe I can at least do something downstairs.
Do they have your, does she have your budget?
I was out yesterday.
Give the Patrick again.
Yeah, we have.
Her email
Okay,
address.
have we finished with the calendar?
Head count?
All right, reserve.
Okay.
Reserve.
I have no updates until I did do the draft decision on cases 310 and 311 as requested. I did email all parties. I don't know if everyone's had a chance to look at it. Yeah. I have it right here. So.
I'll read it at the break that doesn't.
You gave me two.
Okay. I printed out the first couple pages.
Thank you.
Yep. Okay, that was 34 Buffalo?
Yep.
Okay.
We'll hold that. She'll read it at the break.
Thought it was,
Oh, yeah, you sent out 2 different.
Yeah, because it was one for each lot. Yep.
310.
It was very similar,
I
but.
wasn't being critical.
No, that's all right. But with the side yards, only one had it, because one had.
So we're gonna hold that for later?
Yeah,
I
next,
have
page 2.
no updates on page 2. I have no updates.
Did you go out on this one?
January 8th.
Oh, no, not on that one.
No, this Cosgrove.
Yeah.
Then I will.
Hold on.
Can I just ask?
What file do I
Can,
have it?
no. I'm wondering if, I'll look at my photographs. The house right next to it, I'd like to be able to look at the chart for it. I want to see what numbers it has.
Okay. I need the address, though. I think we had a hard time finding it. So if you have the address, that would be very helpful.
I feel like it's 37.
Okay.
No, 27, that's what it is. I remember now, because this is 39. It's 27 Wood Hill.
Okay, I'll try to find that. Okay, on case 46, I did do a draft decision and I emailed it out to all parties. That was that garage that is, part of it's converted to a bar.
Oh, yeah.
I don't know if anyone's had a chance to look at it. Any thoughts, comments, criticisms?
Oh, Joe was in the bar.
Joe wants one of those,
He
that's
was-
what.
I think we all want one of those.
Garage.
God, my wife would throw me out if I ever did that.
You'd be in the garage, that's where you'd get thrown.
I would love it.
That would be,
Yeah.
you would love it.
I'd love it. Hell, I could live in that garage.
You'd have a Murphy bed in there.
There you go.
Space heater.
So, I don't know if the board is,
Any discussions, I guess?
Any discussion on the
Is it
garage?
that bar in the garage?
The bar garage with the car in it?
Yeah.
Yeah, it's Mini Cooper.
and you folks were out, so.
We have no one, we could always say we read the minutes.
If you did, if you did.
I was there, I was
It did not, it had no plumbing, it was just a bar and.
Not to mention, not to mention. Wasn't he the police officer? who had-
Yes.
Yeah.
I don't believe there was any sink, there was no plumbing, and that would have been a condition, commissioner just get converted.
All you have to do, you can,
Thing is on.
Someone else wants to.
I just want, I was waiting for you.
make the motion.
Call it.
All right, cases 45 and 46 of 2025. Belmore, Kevin and Karen Beatty, 609 Orange Street. Belmore, This is variance is lot area occupied, front yard average setback, construct roof over open porch. Attached to dwelling, special exceptions, maintain accessory structure at the garage bar.
I don't think I had the.
Higher and larger than permitted with exceeding horizontal maximum on all sides, with less than required rear and side yard setbacks, and with lot area occupied. Any comments? If not, would someone like to make a
I move that case
Motion.
45, 2025, and 46 of 2025 in Belmore, Kevin and Karen Vahey, that council sent us draft decisions, that we adopt the drafts as is.
second? All in favor? Any opposed?
Since you're pulling files, can you pull that file too? Because wait, not that file.
Are we moving on? Any other, any other cases?
We probably have it. Okay,
Because I can do
okay. So I have a couple of administrative things.
On the administrative. Extensions of time.
All right, so
I think this is the guy who wants to
oh, so wait,
that's a spec.
okay, so one of the plans examiners contacted me. The board's gonna recall there was a subdivision in Baldwin, Erica James LLC, where the applicant proposed
That's the
to
car park,
maintain a
isn't it?
two-family and move it and subdivide the lot.
And make another two-family.
Well, keep the one two-family and build a second house. So it was a subdivision, maintain a two-family, and construct a house. The board denied the application for the two-family.
Wait, slow down. We denied the, maintain the two-family on lesser dwelling, on the lesser lot.
Correct.
It was only for us for that.
And there were kind of issues that I believe the Nassau County property cards indicated it was a two-family,
But was it a legal two-family if they, on the lot it was on?
questionable.
Okay.
The Nassau County records indicated yes. To my recollection, I don't believe that they had town. Regardless, the board denied the subdivision, maintain two-family. They were able to move the house, maintain it as a one, and construct the other house.
Wait, they were able to already move the two-family dwelling over there, but call it a single-family
Correct.
dwelling and as of right.
Well, it was part of the subdivision. It needed relief. Anyway, I'm just briefing everybody on what
I'm
happened.
sorry.
That's okay. So it was just an administrative thing. Our office misstated the location. We had it stated as on the east side of Harbor Street, where it's really on the west side of Harbor Street. So
Misstated it in what, our denial?
no, in our, just how we captioned the case.
Okay.
So it's administrative. We looked at the CNRs that were filed. It didn't affect that because they did it by section, block, and lot, so there were no issues. But it's just administratively, if I need a motion to correct the east side to west side.
No.
Okay.
That's all we need.
As it relates to case 657 of 2023, Erica James LLC, affecting the property at it doesn't have an address.
Because it's a subdivision.
I know, but it was, okay. Which was previously a proposed subdivision in Baldwin at 709 Fisherman's Road. I move that we make an administrative correction to the calendar, to the caption on our calendar, changing where it described it as on the east side of Harbor Street to the correct location, which is on the west side of Harbor Street.
Okay, now, while we're on this case.
Second? All in favor?
Aye. Now, while we're on this
Okay, while
case,
we're on this case, so naturally, when the two-family was being moved, it collapsed and crumbled.
With a really tight grip by the
Correct.
backhoe.
So, what happened was that now that they can't keep that house, they designed a new house. So that is, the plans examiner flagged it just for administrative review. I would like to make the representation that no new variances are triggered by the new dwelling.
But we
again,
don't know that.
We do
What if they're
because
building it larger?
the plans examiner reviewed it. But just because it's different than what we initially saw, he wanted us to just opine on it if we want to.
Wait, What we originally, Christina, what we originally saw was a two-family dwelling that may or may not have been legal as a two-family, sitting in a place. When we denied the lesser lot idea, they decided, did they have to get a permit to move the structure?
Probably.
Yeah.
So let's assume they got a permit and went to move it. While they're moving, the structure itself, it collapses.
Correct.
So now they want to build a new house to replace that house.
Correct.
How do we know without, so did they give the building department plans for it?
Correct, right here. It doesn't trigger any new variances. It doesn't trigger any new
So
variances.
how do we
Does it
come into
trigger any,
play?
I mean, it needs variances for what reason?
None, she says.
No, she didn't say that.
We did the subdivision. It doesn't trigger any new variances, so it would be
Wait,
essentially
what
the
do you mean we
same.
did the subdivision? We granted the
We
subdivision?
granted a subdivision, we denied the portion to maintain a two-family house. They were allowed to maintain that house as a one-family and subdivide the
lesser
lot.
lot.
And subdivide, it was variances, subdivision of lot area, construct three-story dwelling with garage, deck, and roofed over open porch. That was the neighboring property. I don't have the initial caption for this one with me. But the point is that it doesn't, yeah.
We granted that structure on a lesser lot. So we granted the subdivision,
We granted the subdivision.
which means we granted them the right to have that structure on a lesser lot. Or it
Correct,
wouldn't have been,
correct,
right?
correct. They would technically be on a lesser lot, yes.
Did we grant them the right to construct a house on the other lot?
Yes. So we granted the subdivision.
Subdivision.
Correct, so you move the one, construct another.
Right.
Right, so what did we deny?
We denied, they were trying to maintain that as a
We just denied them the
two-family.
two-family.
Correct.
Okay, I misunderstood.
That's okay.
So now, it's been reviewed, and the house they wish to put on the lot we let them create, building department says it triggers no additional variance.
Correct.
And they're building a one-family residence.
Correct. It's a one family, it does not trigger any additional
Then
variances.
I'm okay with you doing that, but I think I want you to specifically say that that the new proposed single-family dwelling reviewed by the building department on this date.
Why do we have to do anything?
I don't think we have to. If you want me to write a
No,
comment,
but she
I'm happy
wanted
to.
to do that.
No, I'm just running it by you guys to make sure
But
you're okay
whenever
with it, you don't
you-
want to bring it back.
But
It doesn't-
whenever you,
It doesn't trigger any
It
additional
doesn't
variances.
need to come back.
We're going to defer to the greater knowledge, and we're not going to pass anything on this, if that's okay with you. We don't need it, we don't need it.
So I'll put a
Right,
comment
that's
in the
it.
portal
Let them deal
stating
with
as
it.
such.
Christina makes a suggestion about the drafting.
Well, let them make it, let them deal with it.
I don't think, she can make,
Yeah, it was her idea.
I just wanted to bring it up to you
We
guys.
we are going,
but
we
she
are,
didn't do any draft.
yeah,
Correct, and
so they're building,
I'm not sure.
I am positive. it's just, we just need a motion to,
Grant the rehearing.
yeah, that's what we want.
You want to do a rehearing then?
What's the case number?
It
That's what you
is,
suggested, isn't it?
what is the case?
I think what we've done in the past with these is that you re-grant you reopen the case, you re-grant the relief, and then it starts the clock again, because do you really want to hear the same exact case again?
Yes.
No, I like that.
Do we,
Yes.
do we ask the question when you come before us and you say you want this kind of relief?
Are you
Do you
able?
have the money now?
No, but then
Yeah,
if we
the
give them
money
another,
was-
if we
it's
give
gonna
them,
be
if
another
we restart the
$6.
clock, if we restart the clock, they got another 16 months to figure it out.
Correct.
This was case, Mr. Regano, case number 584 of 2022.
Mark, hold on.
584 of 2022, it's located at 556 Clubhouse Road in Woodmere. Variances lot area exceeds the number of stories, construct second-story addition, habitable third-story attic, and portico, all attached to the dwelling. It was granted June 29th, 2022 with conditions. They have failed to ask for an extension of time through the course, and
You want to do a
Right,
rehearing?
so-
Yeah, I didn't, it's
And-
3 stories?
Nothing's
it
otherwise
says,
changed.
says 3 stories, but I don't know what the conditions are. Maybe that knocked it down.
We'll pull the grants.
Well,
We'll pull the grants.
it's kind of irrelevant at this point. The point is, it needs an an extension of time, which they failed to do timely. The next relief that they could ask for is a rehearing.
But Christina legally says we can do a sua sponte.
They've requested a rehearing. Consequently, my suggestion is grant the rehearing, let them come
That's fine
back.
with me too. Can we just do it though? Can we just do something?
Somebody want to make that motion?
I move that we grant the
This
rehearing
has to
of
be
the
unanimous.
case number 584 of 2022.
All in favor? Unanimous.
Okay, do you want to start?
Next.
I have one more, but,
JP. He's our extension of time expert.
There's one on here right there, 7th request.
We have about 17 minutes for lunch. What do you want to do?
Can we have it
This
brought in?
Case is
we don't even have time.
requesting for an extension of time.
You're going to get a sandwich after 2 o'clock and eat dinner at 5? What's wrong? What do you have, a tape on?
Out of the country for several months.
Same. Me too. That's why I was like, I need to get.
Maybe we can throw you some
Besides, it's one thing to miss lunch because you're doing something that efficiently.
No on a piece of cheese. I'll go out with you.
no, not anymore.
I'll go out with you. But I'm not going out there.
Just so you know, we CPLR, it's called index number.
I know what it is. I've read that CPLR more often than I want to think about. Various sections of it.
Are we done?
No, one more.
47 out of 51 years.
another modification
Okay,
request.
modification request.
Okay, what happened was subsequent to the board's grant,
Yeah.
okay? Plans,
She's
so we
trying
need-
to tell us.
Yeah, we have a request for a modification. Subsequent to the board's grant, the plans were
Benedica.
modified. Okay?
His brother was here this
And it doesn't
morning.
require any additional relief. However, we do need to change our decision to reflect the appropriate plans. This seems to be a continuing problem that is happening. And it was mentioned that, oh, well, there's so much time between the time the case gets denied until it gets in front of us, but then why is it being changed subsequent to our decision? If you have 6 months, make your changes then.
What's the
present case.
rationale for the change?
Just what the client wanted. So it
And
doesn't.
how different is it from?
It's not, it's marked, it doesn't trigger any additional variances.
But you could still put living quarters theoretically in the basement, it wouldn't change the variances.
True, according to the plans examiner, it's not anything that is, to lose sleep.
Okay.
So,
All right.
we have,
Do we need motion relief?
We need a motion?
we do, and it would be nice if they had put the case number on there.
That'd be a good idea.
I'm sorry,
All right.
this is, you can see. Okay, should we close the,
Oh.
yeah. close?
Make a motion to close the morning hearing.
Second,
Aye.
all in favor?
Aye.
Okay.